Good morning, ladies and gentlemen. Good morning to you. My name is Malia Cohen. I'm chair of the California State Board of Equalization. It is 10:05 a.m. on February 23rd. We have a full agenda today. So with that, I'd like to start this meeting and call this meeting into order. Ms. Taylor, could you please call the roll?
Good morning. Chair Cohen.
Present.
Vice Chair Schaefer.
Present.
Member Gaines.
Present.
Member Vasquez.
Present.
Deputy Controller Stowers.
Present. All right, a quorum is present and the board is called to order. Ladies and gentlemen, let's go ahead and start this meeting off with the Pledge of Allegiance. If you're physically able, please join me in rising, placing your right hand over your heart and repeating the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Excellent, thank you. So just a reminder to everyone and to all the members that and the invited speakers that we are simultaneously sharing an open teleconference call line, and patience is needed to keep the audio clean, to keep the audio clear. So what we're doing is we're asking if you could turn to your speaker, if you could turn on, please ask for your turn to speak after each presentation has concluded, so the transcriptionists can clearly hear and properly record the meeting. Thank you. And members, I'd like to open this meeting, this month's meeting, with an acknowledgement of Black History Month. I was wondering to see if any of my colleagues have any remarks that they would like to share.
Yes, Madam Chair, real quick, if I could.
Absolutely. Floor is yours. Good morning.
I won't steal your thunder on Black History Month. I'll compliment it after you give your presentation, but I would like to just announce to you as well as all the members, and it just basically announced in the beginning of the meeting for the governor's historic appointment of a Court of Appeals Justice Patricia Guerrero to the California Supreme Court on February the 15th. Justice Guerrero is the first generation Californian raised by immigrant parents from Mexico in the Imperial Valley and is the first Latina to serve on the state's highest court. Justice Guerrero of San Diego has served as an associate justice at the 4th District Court of Appeals since 2017 and has authored numerous opinions to protect the rights of consumers, individuals, while also ensuring that defendants' constitutional rights are protected and that all parties are treated fairly and consistent with the rule of law. Justice Guerrero has contributed many hours of pro bono work to the Immigration Justice Project to promote due process and access to justice at all levels of immigration and in the court system. She assisted clients on a pro bono basis in immigration matters, including asylum applications, protecting vulnerable families from litigation, compliance with fair housing laws. I believe this board joins me with congratulating Justice Guerrero on her appointment and shares the governor's confidence that her great analytical skills, work ethic, and dedication to public service will be immense asset to the California Supreme Court. Thank you for this opportunity, Madam Chair.
Sure. Actually, thought your comments were related to Black History Month, so you kind of.
No, that's why I said I didn't want to steal your thunder. I said,
oh, okay.
I'll
Got you.
first.
Do you want to
Now
say
I'll
anything about Black History Month, Tony? All right, Mike Schaefer, I see your hand, please.
Thank you, Chair Cohen. Black History Month is important to me in San Diego, as I come personally to have the good fortune to know some of the biggest names in Black America that are so well known and have ties to San Diego. One is Archie Moore, the light heavyweight champion of the world, who I represented on several things as an attorney and a friend. And the other is a guy named James Meredith, who
is an international icon in that he was the first black student ever admitted to the University of Mississippi. He had the governor at the front door barring him, but he had President Kennedy and Attorney General RFK and 200 federal troops escorting him into class. And I'm so proud to have known him. He had a son that went to the University of San Diego, and he's been to San Diego, and I'm hoping to get him here again. He's 89, and we talk periodically. Thank you, Madam Chair.
Thank you. I appreciate you sharing that. We'll go to Yvette Stowers.
Thank you, Madam Chair. Yes, we are celebrating Black History Month. Black History Month actually started off as Negro History Week, and it was the brainchild of Carter G. Woodson and other prominent African Americans. Since 1976, every U.S. president has officially designated the month of February as Black History Month. And the theme for this year is Black Health and Wellness. A couple noted dates in time. In 1844, Malcolm Bolin Allen became the first African-American licensed to practice law. He had his license, he passed the bar, but receiving clients at that time was a struggle, but he was licensed. In 1921, John W. Cromwell Jr. became the first African-American licensed as a certified public accountant. And then we all know in 1967, Thurgood Marshall became the first African-American to serve as a Supreme Court justice. Thank you, Madam Chair.
Thank you. I appreciate you setting the tone and setting and framing the conversation about what is Black History Month and how it came about. I appreciate that. We'll turn to Senator Ted Gaines.
Thank you so much, Chair Cohen, for this opportunity to recognize Black History Month. And I'd like to recognize Reginald Lewis, who was the first Black businessman to pull off a $1 billion leveraged buyout. He ran the largest Black-owned U.S. company, the first to generate sales of more than $1 billion in a year. A building at Harvard Law School, his alma mater, is the Reginald F.B. Lewis International Law Center. Yet today, the public hardly knows his name, and that's a shame. Lewis broke racial barriers. Ken Frazier, executive chairman of Merck, said Reg Lewis opened a world of possibilities for an entire generation of Black business leaders, unquote. Financier and philanthropist Michael Milken called Lewis the Jackie Robinson of American business. And I'm reciting from an article that was in the Wall Street Journal. So thank you for this opportunity to recognize Black History Month.
Thank you. Thank you very much, colleagues, for acknowledging African Americans' history and their contribution. Throughout the month of February, we already know that millions of Americans have gathered to celebrate Black History Month. The rich history of African Americans extends far beyond this traditional month of February that is set aside by Black History Month. And you heard from our colleague, esteemed colleague, Ms. Yvette Stowers, talked a little bit about the origin of it. Indeed, each day we celebrate our history and we celebrate and acknowledge, but whether consciously or unconsciously, the contributions of the African American culture as well as traditions in the greater American culture. We acknowledge the contributions of our elders, the work each of us are doing every single day, and then the promise of our young people who are coming up behind us that are going to take over the ranks. In celebration of Black History Month, I just also want to highlight that the origins begin in the year of 1915, which was actually 50 years since the end of the Civil War. You heard from Yvette Stowers that there was a Harvard-trained historian by the name of Carter G. Woodson, and there was also a minister by the name of Jesse E. Moreland who founded the Association for the Study of Negro Life and History. And in 1926, the association chose the second week in February to sponsor National History Week to coincide with the birthdays of Abraham Lincoln and Frederick Douglass. You may recall from history that Frederick Douglass was a great abolitionist during the time period of slavery. This recognition of National History Week inspired decades of celebrations of the historic achievements of African American women and men in the United States. Each of these individual celebrations really has been focused on taking and seizing a teachable moment for our country. But slowly and surely, the historic stories are being told. And in 1976, President Gerald Ford formally recognized Black History Month, calling upon Americans to seize the opportunity to honor the often neglected accomplishments of Black Americans in every area of endeavor throughout our history. So you may not know that this year in 2022, the theme of Black History Month is Black Health and Wellness, which is a pretty appropriate thing given that we're coming out of this pandemic. And in keeping with this theme, let me say that the history of Black women and men in this country is more than just a chronicle of tragedy or a chronicle of lost opportunity. This is actually also a history of celebration, of triumph, of accomplishment. So wanted to just take a moment to reflect on the pioneers in the field of medicine and public health. There are some names that I'd like to read for you to consider. Dr. James McCune Smith, who was born in 1813. He's the first African American to attain a medical degree. Dr. Rebecca Lee Crumpler was born in 1831. She's the first Black American physician in the United States. I want to acknowledge more modern day African American contributors. Dr. Mae Jameson, who you may know and recall, she is the first Black American astronaut. She was born in 1957. Dr. Marilyn Hughes Gaston was born in 1939. It's a pediatrician who became the first Black woman to direct Public Health Service Bureau. And let me conclude by celebrating the contributions of three of our California African American leaders in health. First, there's Dr. Eric Gooseby, who was born in 1952. He was raised in my hometown of San Francisco. He is the son of a civil rights pioneer, educator, and a dentist. Dr. Gooseby devoted 35 years to the treatment of AIDS and HIV patients. In 2019, Dr. Nadine Burke, who was born in 1975, she was sworn in as California's first Surgeon General, sworn in by our very own Governor Gavin Newsom. She's a distinguished pediatrician who studied the links between adverse childhood experiences with toxic stress and harmful effects, and how those harmful effects later manifest in adult life. So with that, I'd like to recognize also the life and times of of a man named Bernard Tyson, who was responsible for the delivery of a healthcare system to over 12 million people. He was the president and CEO of Kaiser. We lost him just recently in 2019 at the age of 60. And he had an outstanding and distinguished career of 34 years in public service and public health. So colleagues, I'd like to just close out my remarks and thank you for allowing us an opportunity to celebrate and recognize Black History Month. It is February 23rd, and I'd like to close out on a high note, the celebration of this month. With that, seeing that there are no other comments, we can continue with the rest of our agenda. Thank you. Please call the next item. Ms. Taylor, please call the next first order of business.
Thank you, Chair. Our next first order of business is an announcement regarding public teleconference participation. Good morning, and thank you for joining today's Board of Equalization meeting via teleconference. Throughout the duration of today's meeting, you will primarily be in a listen-only mode. As you may know from our public agenda notice and our website, we have requested that individuals who wish to make a public comment fill out the public comment submission form found on our additional information webpage in advance of today's meeting, or alternatively, participate in today's meeting by providing your public comment live. After the presentation of an item has concluded, we will begin by identifying any public comment requests that have not been received by our board proceeding staff, with the AT&T operator providing directions for you to identify yourself. After all known public commenters have been called, the operator will also provide public comment instructions to individuals participating via teleconference. Guests in our Teams environment may comment on items other than that they are scheduled for during the public comment by raising your hand during the public comment portion of the meeting. Accordingly, if you intend to make a public comment today, we recommend dialing into the meeting on the teleconference line, as the audio broadcast on our website experiences a 1 to 3 minute delay. When giving a public comment, please limit your remarks to 3 minutes. We ask that everyone who is not intending to make public comment, please mute their line or minimize background noise. If there are technical difficulties when we are in the public comment portion of the meeting, we will do our best to read submitted comments into the record at appropriate times. Thank you for your patience and understanding.
Great, thank you very much. Please call the first item.
Our first agenda item will be item AA1, Board Discussion on Emerging Issues Affecting Unitary Value Setting, Value Indicators, and the Reconciliation Process. This item will be presented by Mr. McCool.
All right, thank you. So colleagues and members of the public, today we have a special presentation by Mr. Jack McCool. Jack McCool is the chief of our State Assessed Property Tax Division. This special presentation is made at my suggestion with the concurrence of Controller Yee in response to a motion that was supported by the board. The special presentation will allow the board members and, most importantly, the public to receive an up-to-date review of the emerging issues affecting unitary value setting, including how value indicators are chosen and how value indicators are reconciled. So the reason why this presentation is important, well, setting property values for state assessees is one of the most critical constitutional functions that we perform. And each year we're tasked with reviewing and adopting property tax values of 341 companies in the state of California, including telephone, including gas and electric companies, independent power producers, regulated railroads, and inter-county pipelines. In 2021, the board adopted values of $126.8 billion in assessed property values for state assessees for fiscal year 2021-2022. As you can see, that's a lot of money. And so our actions in adopting these values for state assessees will result in the state and local communities receiving over $1.99 billion in revenues. So these revenues help fund our schools, they help fund local governments, and what it does is that it assures that vital services are being provided. So although the setting property tax values for state assessees is one of the Board of Equalization's most important core functions, the public is often unaware or only slightly aware of this work. So this special presentation is an opportunity just to shed some light on the value setting process. And in the interest of transparency, we welcome this presentation because it will highlight the important work of our State Assessed Property Tax Division. It also highlights our own work as board members when we review the property calculations. And unlike most property in California, the values for state assessed property are adopted each year. This process is outlined in our state constitution and drives the work for our staff. And of course, it drives our own work conducted with our individual offices. So based upon the documentation presented to us by the Board of Equalization staff, we will meet as a board in public session this May and adopt the state assessee property values for 2022-2023. So it is my goal that this presentation will assist not only you or new members of your staff, but also members of the public in understanding the importance of this duty and sustaining revenues that we need to adequately fund our schools and local governments. So with that, I'd like to pivot and introduce today's special presentation. It's a high-level policy discussion. We will not and cannot legally discuss any individual companies. To do so would be a violation of our taxpayer confidentiality and taint our own work in adopting values for companies at our meetings in May. If you have questions, colleagues, please limit your questions to just policy issues only without referencing any state assessee. So with that, I'd like to introduce and welcome Mr. Jack McCool for the special presentation. Thank you, Mr. McCool. The floor is yours.
Thank you, Chair Cohen, for the introduction. As Chair Cohen stated, my name is Jack McCool. I'm Chief of the State Assessed Properties Division. Today, I'll be making a presentation on issues affecting the annual value setting, specifically value indicators and the reconciliation process. As you can see on our first slide, the objectives for today's presentation are to review the annual valuation timeline, provide an overview of the different value indicators used by SAPD, give a summary of why certain value indicators are used for each industry, discuss the reconciliation process, including the weighting of value indicators, and finally, we will review the recent history of the wildfire climate change issue from a valuation perspective and discuss how we go about making adjustments for the wildfire climate change issue. So I would like to begin by reviewing the timeline of the annual valuation process. In January and February, SAPD staff began holding meetings with state assessees. During these meetings, we discuss topics of interest or concern that state assessees have, and we may also discuss new legislation, regulation, or industry developments. It is during these meetings that we first begin to consider areas that may warrant a value adjustment. We also begin work on our annual capitalization rate study. Rates derived in this study are used in the income approach value indicators and are developed using market data as well as industry input. Staff are also working on developing the annual condition percent good and replacement cost new factors. These factors are used in our cost approach value indicators and are developed using both market and industry data. The annual valuation timeline continues through March, April, and early May. The annual property statements submitted by state assessees are due beginning March 1st. Assessees can request a filing extension, and in most cases, these extension requests are granted. SAPD staff also continue to meet with state assessees during this period. We may request additional data or information based on these discussions. It is during this period where we begin to formulate value adjustments based on information gathered during our meetings with state assessees. During this time, SAPD staff continue completing unitary appraisals, and each completed appraisal goes through several levels of review. In addition, assessees have the opportunity to review their appraisal and the work papers. Continuing with the valuation timeline, in mid-May, SAPD transmits the confidential value indicators and the final value estimates to the board in the form of the appraisal data reports for the board's consideration. During the annual unitary value setting at the May board meeting, the board adopts the unitary values. Notification of assessed values come in several forms. First, BOE's Communications Office issues a public news release which announces each assessee's board-adopted unitary value. Staff also send each assessee a notice of unitary value by June 1st of each year, which is required by the Revenue and Taxation Code Section 731. A notice of allocated assessed values is then sent by June 15th, as required by Revenue and Taxation Code Section 746. That brings us to the topic of value indicators. Value indicators are estimates of market value for state assessed property that are calculated according to recognized appraisal principles and statutory requirements. Property Tax Rule 902 states in part that each year SAPD shall, quote, develop value indicators applicable to the unitary property of each state assessee, end quote. More than one value indicator may be calculated for each assessee. The appraiser must decide which indicator or indicators represent the best estimate of the property's value. To summarize, a value indicator is simply the value estimate that an appraiser calculates using one of the widely recognized approaches to value. There are several recognized approaches to value. Property Tax Rule 3 provides that, quote, the assessor shall consider one or more of the following as may be appropriate for the property being appraised, end quote. Comparative sales approach, stock and debt approach, placement or reproduction cost approach, historical cost approach, and the income approach. So let's take some time now to review the approaches to value used by SAPD. The cost approach value indicators used by SAPD are the historical cost less depreciation, or HCLD for short. This is the historical or original cost of the property minus the accumulated depreciation. It is an important indicator for closely regulated public utilities. SAPD also uses the reproduction cost less depreciation approach, which is the estimate of current cost to replace existing property with a new exact replica. Staff uses index factors applied to the cost of the property adjusted by a percent good factor to calculate the amount of depreciation. Replacement cost less depreciation is the estimate of the current cost to replace existing property with a new equivalent. Here, staff use index factors applied to the cost of property by year and then adjusted by a percent good factor to calculate the amount of depreciation. On this slide, we see that the income approach value indicators used by SAPD. Our main income approach indicator is the capitalized earning ability, or CEA approach. The CEA is a method that converts future anticipated income into present value. SAPD primarily utilizes two types of CEA value indicators. The first is the perpetual life model, which assumes that the income stream is sustained into perpetuity. The second is the limited life model, which assumes the income stream has a finite life. The term, when using the limited life model, is usually tied to a contract or other defined document. SAPD also uses the net liquidation value indicator, also known as the salvage value. This approach is based on the principle that the highest and best use of the property would be to sell the assets for the liquidation value rather than continuing to operate the company as a going concern. The salvage value indicator is used mainly for certain short line railroads. The sales approach value indicator used by SAPD is a variation of the traditional comparative sales model. The nature of utility companies makes them less likely to be subject to sales. Additionally, there are usually very few comparable sales of utilities that our appraisers can use to calculate a comparative sales value indicator. Instead, our staff will attempt to obtain details of a sales agreement that pertains to the portion of the sales price that was allocated to the physical assets. Staff must also remove assets exempt from taxation from the sales price as part of calculating the sales model value indicator. Now that we have reviewed the value indicators used by SAPD, I thought it would be helpful to review applicable parts of the appraisal process before we move to the next topic, which will be a review of which indicators we calculate for each industry and the reasoning behind that. Part of our appraisal process is to evaluate which value indicators make the most sense for each industry and also for each state assessee's unique circumstances. The appraisers always review the prior year appraisal before beginning the appraisal for the current year. Part of that review will include a review of any prior year petition issues, if there were any. Appraisers will also consider what data is available, whether and how the assessee is rate regulated, whether the assessee has a stable income stream, whether the income data includes data for a parent company or a subsidiary, and various other questions along these lines. Based on what is learned in the above process, appraisers will then calculate the indicators they feel are most applicable based on the property statement data submitted by the state assessee. While working on the appraisal, the appraiser will make any value adjustments deemed necessary. This could be based on information brought to the appraiser's attention during the previous meetings with the assessee or during the exchange of information during the appraisal season. Decisions to make an adjustment typically involve senior appraisers and managers in addition to the appraiser. The appraiser will then reconcile the value indicators, which we will cover in more detail later in the presentation. But reconciliation is a process by which the appraiser must carefully choose the most appropriate value indicator or indicators. Finally, the appraiser must present the final value estimate. In SAPD's case, this is done via the confidential appraiser data reports provided to the board annually each May. Now I'd like to take some time to review the value indicators that we typically use for each industry group and why we use those particular indicators for each industry. First, I would like to review the value indicators typically used for our gas and electric industry. For investor-owned utilities, the primary value indicator is the historical cost less depreciation, or the HCLD value indicator. The perpetual life CEA is also typically given consideration for these types of assessees. There are several appraisal texts that state that the HCLD is a reliable indicator of market value for closely regulated public utilities. They include the Assessor's Handbook 502 Advanced Appraisal on page 146, the Unitary Valuation Methods book on page 1, and the Western States Association of Tax Administrators Handbook, page 11-8. Gas and electric industry value indicators are continued on this slide, where we will have further support for using the HCLD value indicator for rate regulated utilities. According to Property Tax Rule 3D, the assessing agency shall consider as relevant to value the amount actually invested in the property, less depreciation, if the income from the property, parentheses, rate of return, in parentheses, is regulated by law and the agency uses historical cost depreciation as a rate base, end quote. Utilities that are closely regulated are subject to rate-based regulations, which means their authorized earnings or rates of return are set by regulators. Continuing with the gas and electric industry, for electric cooperatives, the primary indicator is also HCLD. These companies are also regulated by the CPUC, but are not directed toward profit making. For gas transmission companies, the primary indicator is HCLD, as regulated by the Federal Energy Regulatory Commission, which is considered closely regulated. The companies are SAPD will also consider the CEA indicator for companies showing reliable income streams. The gas storage companies we assess are not subject to the traditional rate-making process, so the HCLD indicator is generally not used. Instead, the reproduction cost less depreciation and CEA indicators are typically both considered. Next, we will review the electric generation value indicators. For newer facilities, the replacement cost less depreciation and CEA value indicators are typically given equal reliance. Replacement cost less depreciation reflects the replacement cost of current technology, while the CEA is considered reliable due to the reduced volatility in income projections for newer facilities. When it comes to older facilities, the specific reliance on the replacement cost and the CEA value indicators varies depending on the predictability and reliability of the future income streams. Our staff must consider whether the facility has a long-term contract, a short-term contract, or in some cases, no contract at all. To summarize, it is important to consider the age of the facility and length of the contract when determining the use of these value indicators for this industry. For the inter-county pipeline industry value indicators, the primary indicators for common carrier pipelines are the reproduction cost less depreciation, historical cost less depreciation, and the CEA. The use of reproduction cost and CEA is based on the assessee's specific factors. Non-regulated natural gas transmission pipelines are typically valued using reproduction cost less depreciation, and non-common carrier pipelines are also valued primarily using reproduction cost. These assessees are usually subsidiaries of other petroleum or mineral extraction companies, which makes obtaining accurate income information difficult. For the railroad industry value indicators, the CEA value indicators are considered most appropriate. Reproduction cost less depreciation is used only sparingly in the railroad industry due to the old age of many of the assets and the difficulty is estimating depreciation. For the large Class 1 railroads, staff rely mostly on the perpetual life CEA using the most recent year's income. The perpetual life CEA is also the primary value indicator for most of the short line railroads. However, in some instances, the salvage indicator, otherwise known as the net liquidation value indicator, is used. This indicator would be calculated when the highest and best use of the property would be to disassemble and sell the component parts of the railroad rather than to continue the railroad as a going concern. Moving on to the local telephone industry value indicators. Overall, the HCLD and replacement cost value indicators are primarily used for these assessees due to regulation and market trends. The CEA indicator is given consideration in some cases based on assessee-specific circumstances. Traditional landline telephone companies are valued primarily using the HCLD indicator, as these are companies that provide traditional landline telephone services and continue to be rate regulated. For the larger local exchange companies, the primary indicator is replacement cost less depreciation, and the CEA indicator is also considered. These assessees have incentive-based rate regulation, which differs from traditional rate regulation. These assessees also face increasing competition from other providers, such as cable companies and competitive local exchange providers. Replacement cost less depreciation is considered the most reliable value indicator for the wireless telephone industry. These assessees are not closely rate regulated. This is also a highly competitive industry, experiencing significant advances in equipment technology, and reliable replacement cost data is available. The CEA value indicator is sometimes considered, but is generally not relied upon, as it may include value related to non-assessable property. Finally, we have our inter-exchange industry value indicators. These assessees are comprised of long-distance carriers, alternative access providers, satellite communications providers, and other hybrid telecom services. The primary value indicator used to value assessees in this industry is the replacement cost less depreciation indicator. Similar to the wireless industry, these assessees are not rate-based regulated and have highly competitive economic conditions that continue to result in contraction of companies and the convergence of services. The CEA indicator is not considered reliable due to the uncertainty of the current income continuing into the future. So before moving on to the next topic, I would like to summarize the value indicators typically used in each industry group. As you can see on the displayed chart, the gas and electric industry typically utilizes the HCLD and CEA value indicators. The electric generation group primarily uses the replacement cost and CEA indicators. The pipeline industry usually considers the HCLD, reproduction cost, and CEA value indicators in their valuations. And the reproduction cost, CEA, and salvage indicators are used in the railroad industry. The local telephone industry mostly relies on the HCLD, replacement cost, and CEA value indicators, while the wireless industry relies on the replacement cost and CEA indicators. The replacement cost indicator is also the primary value indicator of the inter-exchange industry. Displayed on the next slide is a pie chart illustrating the percentage of state assessees by industry. So members, the point of this slide is to illustrate how many assessees we have in each industry group and to give you an idea of which value indicators are used the most by SAPD. Beginning at the top right of the pie chart, you will see that the electric generation industry comprises 12% of the total number of state assessees. As we discussed a few moments ago, the replacement cost and CEA indicators are typically used to value these assessees. Moving downward in a clockwise manner, you will see that the gas and electric industry has 9.5% of our state assessees. And if you recall, the HCLD indicator is generally considered the most reliable value indicator for this industry, with consideration also for the CEA indicator. The pipeline industry makes up about 7.4% of the total number of state assessees, and we use a combination of the reproduction cost historical cost less depreciation, and CEA indicators for these assessees. Continuing downward on the right-hand side, you will see that the railroad industry makes up about 10.6% of the total assessees. And as mentioned, we typically use the CEA models to value assessees in this industry. The local telephone industry makes up only 5.4% of our assessees, and we mostly use the replacement cost indicator with some use of the historical cost less depreciation indicator. Finally, completing our clockwise direction, you will see first that the wireless industry is 7.2% and the interexchange industry is by far our largest industry group at 47.9% of all state assessees. As just discussed, the replacement cost indicator is the primary value indicator for both of these industry groups. So members, I hope that helps to put into perspective how the different value indicators or approaches to value are utilized by the State Assessed Properties Division. Now we will move into the final phases in the appraisal process: reconciliation and the final value estimate. According to the Assessor's Handbook 501 on page 110, the final analytical step in the appraisal process is to reconcile value indicators from the separate approaches utilized in the appraisal into a final estimate of value. Resolving the differences among the value indicators is called reconciliation, and the result of reconciliation is the final value estimate. According to the Appraisal Institute, reconciliation of the value indicators is, quote, the process by which the appraiser evaluates, chooses, and selects from among value indicators to reach a final value estimate, end quote. The Institute goes on to say that, quote, the appraiser must rely on their experience, expertise, and professional judgment to determine the validity of each value indicator and appropriateness for the property being valued, end quote. That text can be found in the Appraisal Institute's Understanding the Appraisal on page 13. The word reconciliation has different meaning in accounting versus in appraisal. According to the Oxford Dictionary of Accounting, in accounting, reconciliation is a procedure for confirming that two sets of records are in agreement. In appraisal, reconciliation is a process in which the appraiser conducts an analysis of the relative appropriateness of the approaches applied, the accuracy of the data collected and the calculations made, the quantity of the data available for each approach, and the consistency in the manner in which the approaches to value were applied. That definition is according to the Assessor's Handbook 501, Basic Appraisal, page 110. That brings us to the weighting of indicators as part of the reconciliation process. Deciding how much weight should be placed on each value indicator is part of the reconciliation process. As the Appraisal Institute describes on page 13 of Understanding the Appraiser, the appraiser weighs the relative significance, applicability, and defensibility of each approach and relies most heavily on those most appropriate to the intended use of the appraisal, end quote. The Western States Association of Tax Administrators has further guidance in their handbook, specifically on page V11-4, in which the text states that, quote, averaging the value indicators is not a proper method since it would imply that all value indicators are equally valid, and this is rarely the case. Use of an average bypasses the proper application of an appraiser's experience, expertise, and professional judgment to resolve the differences in the value indicators, end quote. To summarize, the appraiser is drawing on all of their appraisal experience, expertise, and judgment to carefully evaluate the appropriateness of the approaches, the quality and quantity of the data available to determine how much weight should be attributed to each of the value indicators. And that brings us to the final value estimate. The final value estimate is an appraiser's expert opinion of value supported by verifiable data. There is no mathematical formula or statistical technique, as we just discussed. It is an opinion that should be based on the appraiser's application of generally accepted appraisal methods and procedures, taking into consideration each state assessee's unique situation. I would now like to discuss how SAPD shares reconciliation and the final value recommendation with the board. The State Assessed Properties Division annually transmits the value indicators to the board in the form of the Appraisal Data Reports, or ADR, prior to the May value setting. The appraisal data reports show the value indicators that were calculated, as well as the weighting assigned to each value indicator. The reports also show staff's final value recommendation. SAPD also includes appraisal narratives with ADR for most of the larger state assessees, which document each appraiser's reconciliation of the value indicators. The appraisal data reports are considered confidential under Revenue and Taxation Code Section 833 and Government Code Section 15619. As we move into the last phase of today's presentation, I would like to discuss the recent history of the wildfire and climate change issue. This is an evolving issue that SAPD has been working on with investor-owned utilities since at least 2017. We have been engaged with industry and assessee representatives every year since the issue first surfaced many years ago. Early discussions focused mainly on how to address climate change and wildfire risk and how to account for that risk in the appraisal. Much speculation in the early years centered around what action the CPUC and/or the legislature may take. There was a productive discussion at the February 2018 board meeting that included an assessee representative and the SAPD chief at the time. Part of the conversation discussed the difficulty in quantifying the impacts of climate and wildfires on the taxable property. There are many challenges related to the wildfire climate change issue. From a valuation perspective, the difficulty for SAPD and the utilities is how to quantify the impacts. Specifically, how does this issue affect the value of the physical assets? There isn't much data available for appraisers to evaluate. SAPD is not a climate change expert, and as we do on similar issues, we defer to the regulators, the CPUC, and other industry experts. So when it came time to make our first adjustments for the wildfire climate change issue, SAPD made adjustments for the 2019 lien date based on the cost of capital applications that investor-owned utilities submitted to the CPUC. These applications submitted by utilities to the CPUC were among the first sources of data that attempted to quantify the impacts. SAPD made a decision to be proactive and allow for an adjustment in our valuations based on this data for the 2019 valuations. New legislative and regulatory developments occurred in time to affect our 2020 valuations. Specifically, the legislature passed Assembly Bill 1054 in the second half of 2019, which established a wildfire insurance fund and included other provisions, all designed to stabilize credit markets for the investor-owned utilities. The CPUC also announced rate case decisions for the major utilities in December of 2019. The investor-owned utilities had included requests for an equity risk premium in their rate case applications, but the CPUC ultimately denied this request, stating that AB 1054 and other policies had, quote, mitigated wildfire exposure faced by California's utilities, end quote. SAPD met with the utilities in early 2020 to discuss AB 1054 and the CPUC rate case decisions. Part of the discussion centered on how to treat payments to the AB 1054 wildfire fund, the required mitigation costs, and other provisions. The topic of the equity risk premium adjustment denied by the CPUC was a major component of these discussions with utilities, with the utilities contending this risk premium better quantified the risk the utilities were facing. This brings us to the value adjustments made in response to the CPUC rate cases and Assembly Bill 1054. SAPD considered all of these conversations carefully. We analyzed the CPUC decisions and analyzed the provisions of AB 1054. SAPD made adjustments for the wildfire climate issue for the 2020 lien date based on the new regulatory and legislative events. After the 2020 petition season, SAPD did a careful analysis of factors affecting the indicator weightings and decided that our confidence level in the weighting of the value indicators remained the same. Our analysis was based on the reliability and the quality of the data available. Part of our consideration is the fact that the investor-owned utilities continue to replace old property with significant amounts of new property, which is also consistent with reliance on the cost approach. As we look ahead, SAPD will continue to monitor all aspects of this evolving wildfire climate change issue related to valuation. At this time, no new legislation or regulation affecting state assessment is pending. We will continue to engage with the utilities, and we will continue to consider studies and data presented by state assessees. Members, that concludes my presentation on value indicators and the reconciliation process. Thank you.
Awesome. Thank you for that very thoughtful and thorough presentation. Let me see if my colleagues have any questions. All right, Mr. Vasquez, go for it.
Just real quick, first of all, thank you, Mr. McCool, for that in-depth presentation. And I know you and your staff must have spent quite a bit of time in preparing this. But I have, I guess, a couple of questions. One, in terms of the value indicators, you kind of touched on that. How long has it been since the department went back to see if such value indicators are current with today's specific issues? Kind of like what you mentioned with the wildfires and disasters.
Yes, thank you for the question. So specifically with the wildfires, because it's an evolving issue, it is something that we do revisit every off-season. Generally speaking, when we talk more broadly about all industries, we're fortunate enough to have senior appraisers who are devoted as an industry lead for each of these industry groups. And part of their responsibilities are to monitor issues affecting each industry. And part of that is to analyze whatever information that we can get our hands on to determine if the indicators that we're using remain as appropriate as they have been in the past. So to answer your question, it really is an annual process by which we're reviewing issues specific to each industry to determine if the indicators, not only the indicators, but specifically the weighting applied to each indicator, it remains appropriate.
Thank you. And then my second one was, has the department looked at trends in appraising methodologies, such as establishing value indicators used by specific industries used by other states with similar appraising issues? And does the department see the need to adjust appraising methods to adjust for issues that weren't major concerns 10 years ago?
Yeah, so again, I think that as part of our annual process, adjusting whether we're talking about indicators themselves, the weighting applied to them, but also more specifically, adjustments made within each appraisal. That is an annual evaluation that we do intake. As regards to other states, we are a member of the Western States Association of Tax Administrators, and we do meet on a regular basis with that group. Up until recently, we actually had a committee member on their central committee, and this association allows us to reach out to our similarly situated partners in other Western states and discuss appraisal issues. We've discussed wildfires, we've discussed a number of issues, and while the specific laws regarding valuation may differ in other states, there is some commonality within central assessment, and we do reach out to other states and discuss how specific types of companies are appraised, and we rely on those conversations as well when informing our decisions for the current year.
Thank you. And then just one last quick one. Can you touch on the process where there is a big discrepancy between the two valuations like HCLD and CEA, in which the implied conclusions in this situation is due to obsolescence? I understand it is ultimately the appraiser's opinion to verify or confirm that the differences are in fact due to the obsolescence.
Sure, thank you for that question. So, I know there's some language in one of the handbooks that says that HCLD, basically minus the CEA value indicator, may be a result of obsolescence. And I think the key word there is may, because HCLD minus CEA does not necessarily equal obsolescence. So specifically when you talk about closely rate-based regulated utilities, the two indicators should in theory be close, but in practice this doesn't always occur, and there can be several reasons for that. The two main reasons often cited in appraisal texts are regulatory lag and also management. There's other factors as well. There's discussions about inter-year accounting adjustments, and then also deviations from any established earning projections that was part of the CPUC rate case decisions. But most texts will focus on regulatory lag and management of the assets. And regulatory lag, as we've discussed in previous public hearings, is the time period between when the utilities rates go into effect and then its next rate case. So, basically the thought is you were given approval to increase your rates, but you haven't yet realized those revenues in your reporting. So it will artificially depress the CEA indicator, which can in part explain the difference between the two indicators. And then also under traditional rate regulation, rates are set on the utility's prudently incurred costs. So if a utility is able to improve its operating efficiency after a rate case, the utility could in theory see increased profits, much like you would see in a competitive market. And then on the other hand, if the utility becomes less efficient or is unable to contain its costs after a rate case decision, they might actually earn less than what they're authorized to earn. So because the CPUC allows the utility the opportunity to earn a set rate of return, that doesn't guarantee the utility will actually earn that level of return. And that's where the text will discuss the idea of management of the assets coming into play. If there's imprudent management, the utility could earn less than what a different operator that's more efficient. A less efficient operator could, in theory, earn less operating those assets than a different operator operating the same assets that's more efficient could actually earn. So that's another reason why we've generally placed more reliance on the HCL indicator than the CEA indicator, is this is very difficult to quantify either one of those items, whether it's regulatory lag or differences due to management and imprudent costs.
Thank you, Madam Chair.
All right, thank you very much. Ms. Yvette Stowers.
Thank you, Madam Chair. I don't have a question, just an observation. I want to say thank you to Ms. McCall for your presentation. I found it very informative. You did an excellent job of protecting taxpayer confidentiality, and hopefully the information was helpful for the general public. As we know, value setting is $119 billion, resulting in almost $1.8 billion to local government. So it's very important that the process of value setting is accurate, fair, and transparent. I especially appreciate SAPD's communication with state assessees and providing them with the opportunity to review the appraisal and the work papers before the values are adopted by the board. That way, these assessees are aware in advance and they have an opportunity to bring in additional data if necessary. So I like that collaboration and working together. Thank you, Mr. McCall. Thank you, Madam Chair.
Thank you.
Colleagues, anyone else have any comments? Mr. Gaines, did I see you?
Yeah,
Yes,
thank
please,
you,
go ahead.
Chair Cohen. I appreciate it. And my question, number one, yeah, appreciate the presentation. And I was just highlighting this wildfire climate change issue in terms of the mitigation measures put in place as a result of AB 1054. And, I know we're following the guidelines based on the statute, but my concern is, are we setting aside enough money in the mitigation fund to offset the exposure from wildfire?
Yeah, thank you for the question. I know that is an open question that is discussed in the CPUC rate case decisions that were made public in December of 2019. It's certainly outside the realm of our assessment jurisdiction to comment on whether it's sufficient amount to cover the expenses, but I do know that it is an open question that the PUC and the investor-owned utilities have debated, and I don't know what the answer to that, if there is sufficient money being set aside for that or not. I do not know.
Mm-hmm. Okay. Well, I imagine the PUC would be hopefully looking at that on a regular basis and making adjustments accordingly.
Of course.
Feel that it's not enough set aside or too much. But thank you very much. I appreciate this presentation. I think the only other question I would have, which is not related to state assessed, but we've had questions and discussion on this board as it relates to the pandemic and the effect on property values. And I'm wondering if, and this would be through the chair, if we could take a look at that at a future meeting to see what the impact has been. Obviously, a lot of businesses struggled through the pandemic, and there's even been a cultural shift where people just aren't coming into the city center like they used to, and a lot more people are working out of their homes. So what is the impact on office space, for instance, in downtown LA or San Francisco or Sacramento? But that would be for another day. Thank you.
Thank you.
I appreciate that, Senator Gaines, and we will definitely look on getting that on the future agenda. Okay.
Great. Thank you.
All right, Mr. Schaefer, Mr. Vice Chair, unmute yourself, and the floor is yours.
Thank you. Chair Cohen, you've spoken of the extensive wildfire damage and how it's affected so many taxpayers. We don't see much evidence of that coming in on the board level. We did have the Southern California Edison $2.9 billion reduction to $2.8 billion a few months ago. I assume there's an extensive amount of this handled by settlement within the assessor world that we don't really know about. Is the assessors reporting to us going to give us an update on what's maybe off the record being voluntary actions by the assessor and making reductions? We don't really have to get involved, if the assessor finds merit in the damage claims, and I think that's what's going on. Will we be hearing a little more about how the assessor world is treating this outside the really big ticket items that end up with the board?
Who are you directing your question to, Mr. McCool, or to me?
Well, to Mr. McCool, yes,
Okay.
And if yourself had to comment on it too.
Okay, Mr. McCool, do you want to take a stab at that one?
Sure. Thank you for the question, Vice Chair Schaefer. In regards to homeowners and damage resulting from wildfires, that is the purview of the local assessors and I know they work very diligently and prioritize the work related to processing those calamities resulting from wildfires. I know that's a priority for each assessor who experiences those tragedies within their counties. I'm certainly not an expert on how the assessors go about processing those claims, and I certainly don't have any numbers regarding the effect on valuation or a total reduction in value related to wildfires. I'm sure that at a future meeting, it could be a potential topic for both the property tax department here and potentially the Assessors Association, but that is a function of the local county assessors, and I do know that it is an absolute priority for them.
Thank you. And they all know that our heart is with the homeowners. Thank you.
Yep. All right, thank you. Colleagues, seeing no other questions, Mr. McCool, you've done an outstanding job in the presentation. I appreciate it. You have delivered in exactly what I wanted and how I envisioned it. Deputy Chief Stowers, please report back to the controller and let her know that we had a good discussion. Let's go ahead and see if there's any public comment on this item.
Thank you. AT&T moderator, please let us know if there is anyone on the line who would like to make a public comment regarding this matter.
Ladies and gentlemen, if you wish to make a comment, you may press 1, then 0 on your touch-tone phone. You may remove yourself from the queue at any time by pressing 1, 0 again. If you're using a speakerphone, please pick up the handsets before pressing the numbers. Once again, if you have a public comment, you can press 1, then 0 at this time. At this time, it appears nobody's queuing up.
Thank you. All right, please call the next item.
The next item is C1A, public hearing, property taxes, presentation on capitalization rates and other factors affecting values, state assessees and/or representatives' presentations on capitalization rates and other factors and procedures affecting fiscal year 2022 to 23 property values of California public utilities, railroads, and pipelines. This matter will be introduced by Mr. McCool.
Good morning again, Chair Cohen and honorable members of the board. Once again, I'm Jack McCool, Chief of the State Assessed Properties Division. I am here to introduce the State Assessee's presentation on capitalization rates and other factors affecting value. Under Property Tax Rule 903, the board provides state assessees with the opportunity to make public presentations regarding the valuation of their unitary property. These presentations are informational and do not require any board action. I am not aware of any state assessees that are planning on making a presentation today. However, I will note that the State Assessed Properties Division staff has met with several state assessees already this year to discuss matters related to the upcoming valuation season, and we have additional meetings scheduled for the remainder of this month. We will also continue to make ourselves available to any state assessee that would like to meet with us. That concludes my presentation for this item. Thank you.
Colleagues, any questions for Mr. McCool? All right, seeing none. Ms. Taylor, do we have any scheduled speakers or public comment?
We do not have any scheduled speakers, so we will call for public comment. AT&T moderator, please let us know if there is anyone on the line who would like to make a public comment regarding this matter.
Once again, if you would like to make a public comment, please press 1, then 0 at this time. At this time, we have nobody queuing up.
So, all right, thank you very much. Colleagues, we have no other questions, so Ms. Taylor, please call the next item.
The next item is C1B, public hearing, property taxes, presentation on capitalization rates and other factors affecting values. private railroad car assessees and/or representatives' presentations on factors and procedures affecting fiscal year 2022 to 23 taxable values of private railroad cars. This matter will be introduced by Mr. McCool.
Great.
Good morning. Good morning once again, Chair Cohen and honorable members of the board. Once again, for the record, my name is Jack McCool with the State Assessed Properties Division. Property Tax Rule 903 also provides private railroad car taxpayers an opportunity to make public presentations to the board on factors affecting the taxable values of private railroad cars. I am not aware of any private railroad car assessees that are making presentations today. However, their annual property statements are due on April 30th, and they have another opportunity to make public presentations to the board in April if they so choose. Thank you.
All right, thank you. Colleagues, any questions? All right, let's take public comment.
Thank you. AT&T moderator, please let us know if there was anyone on the line who would like to make a public comment regarding this matter.
Once again, if you have a public comment, you can press 1 then 0 at this time. And nobody has queued up.
Okay, great. Thank you. Next item.
The next item is E3A, Tax Program Non-Appearance Matters, Adjudicatory. Legal Appeals, Property Tax Matters, Section 40 Decisions. Southern California Edison Company, 0148, SAU 21-007. This matter will be presented by Ms. Garrett.
Good morning, Chair Cohen and honorable members. I am Sarah Garrett, an appeals attorney for the board. Members, as you'll recall, Southern California Edison Company's 2021 appeal was decided by the board in December 2021. This decision was final at the time it was made by the board. However, as the amount in controversy exceeded $500,000 in tax, under Revenue and Taxation Code Section 40, the board is required to adopt and publish a written decision to the board's website within 120 days of the original decision. This allows for transparency and memorialization of the board's decision. A draft non-precedential written decision has been submitted for your consideration. The appeals attorney recommends that the board adopt this written decision to fulfill the board's obligations under Section 40. Thank you.
Great, thank you. Colleagues, any questions? All right, let's go ahead and let's take public comment and then we'll take a motion.
AT&T moderator, please let us know if there is anyone on the line who would like to make a public comment regarding this matter.
Thank you. No one has queued up.
All right, thank you. Is there a motion?
So moved, Chair.
Thank you. Is there a second? Okay, motion made by Vasquez, second by Schaefer. Please call the roll.
That motion was by Ted Gaines.
I'm sorry.
Is there
right.
confusion? Yes, it was with Ted Gaines, provided would be the first, and the second was Vice Chair Schaefer?
No. The motion was made by Vasquez and it was seconded by Schaefer.
Thank you very much, Chair Cohen. The motion on the floor is to adopt the non-precedential Section 40 written decision for Southern California Edison Company. Chair Cohen.
Aye.
Vice Chair Schaefer.
Aye.
Member Gaines.
Aye.
Member Vasquez.
Aye.
Deputy Controller Stowers.
Aye.
The motion passes.
Great. Thank you very much.
The next item is E3B, Tax Program Non-Appearance Matters Adjudicatory, Legal Appeals, Property Tax Matters, Section 40 Decisions, Russell City Energy Company, LLC, 1151 SAU 21-008. This matter will be presented by Ms. Garrett.
Thank you, Ms. Taylor. I believe it was 028, just for the record.
Thank you.
Good morning again, Chair Cohen and honorable members. Once again, I am Sarah Garrett, an appeals attorney for the board. Similarly, the 2021 Russell City Energy Company, LLC appeal was previously decided by the board in December 2021. The decision was also final at the time it was made. As this case had an amount in controversy that exceeded $500,000 in tax under Revenue and Taxation Code Section 40, the board is also required to adopt and publish a written decision to the board's website for this case to allow for transparency and memorialization of the board's decision. A draft non-precedential written decision has been submitted for your consideration. The appeals attorney recommends that the board adopt this written decision to fulfill the board's obligations under Section 40. Thank you.
All right, thank you very much. Members, any questions or? All right, seeing none, let's take public comment.
AT&T moderator, please let us know if there is anyone on the line who would like to make a public comment regarding this matter.
Thank you, and no one has queued up.
All right, thank you. Let's see, is there a motion on this item?
Motion to approve.
Motion made by Senator Gaines, second by Vice Chair Schaefer. Please call the roll.
The motion on the floor is to adopt the non-precedential Section 40 written decision for Russell City Energy Company. Chair Cohen.
Aye.
Vice Chair Schaefer.
Aye.
Member Gaines.
Aye.
Member Vasquez.
Aye.
Deputy Controller Stowers.
Aye.
The motion passes. The next
Great.
item is F1A, C, and D, other tax program non-appearance matters, property tax matters. And this item includes two items, audit and roll change. First, Mr. McCool will present the audits, which may be voted on individually or collectively. Contribution disclosure forms are not required for these items. As these matters are a constitutional function, Ms. Stowers is not participating in accordance with Government Code Section 7.9. The audits are A, CBTS Technology Solutions LLC 2470. C, Network Innovations Incorporated 8154. D, Call Fire Incorporated 8220. This matter will be presented by Mr. McCool.
Awesome.
Good morning again, Chair Cohen and honorable members of the board. Jack McCool, Chief of the State Assessed Properties Division. The State Assessed Properties Division performs routine audits of state assessees under the authority of California Revenue and Taxation Code Section 828 and Government Code Section 15618. The purpose of the property tax audit is to determine the accuracy, completeness, and reliability of the financial data furnished by state assessees and used by the board in the valuation process. Audits also include an internal review of the methods, calculations, and assumptions used by the State Assessed Properties Division staff. Before you today for your consideration are 3 property tax audits completed by State Assessed Properties Division staff. The assessees have been presented with a copy of the audit report and provided an opportunity to provide additional information in response to the audit report. None of the assessees to date have provided additional information. I am available to answer any questions if needed, and I ask for your adoption of these 3 audits. Thank you.
All right. Colleagues, any questions about the audits?
This is Member Gaines, if I
Senator
could.
Gaines, go ahead.
It's just a question of clarification. Can you go over the audits? Because I believe one of these was deleted from our agenda.
That is correct. The deleted company, as part of our process, each state assessee is provided a 30-day notice when we submit them the audit findings and the full audit report. The 30-day notice will give them a window to provide additional information for us to consider prior to board action. So for that particular assessee, they were pulled from the agenda because while they did not initially suggest they would provide information, they did provide us with additional information within that 30-day window. So we have removed that item from this month's agenda so that we may consider the information they provided in full.
And what are those 3 that are remaining, just for clarification to me?
The 3 remaining companies are CBTS Technology Solutions LLC, number 2470, Network Innovations Incorporated, number 8154, and Call Fire Incorporated, 8220.
That's great. And then should these be presented in separate motions? Question through the chair. I don't know if we're voting on each of these individually or.
Well, we're the board. We're the board. We can decide. What would you like? Would you like
Well,
it individually, or I was just going to take them all together?
Yeah, that's
Let's do them
fine.
together.
Okay, yeah, that's what I was going to do. Take it all together. If that's okay with everyone, we seem to have a consensus. So, perfect. Okay, Mr. McCool.
It's the pleasure of the board. I ask for the adoption of the 3 property tax audits under your consideration.
So
Alright.
moved.
So this does require a board action, yes.
Yes, thank you. Before we take that vote, we do need to take public comment. So we'll take up that motion in a second. Ms. Taylor, could you please go to the public?
Thank you. AT&T moderator, please let us know if there is anyone on the line who would like to make a public comment regarding this matter.
Thank you. No one has queued up.
All right. Well, let's see. There was a motion to adopt was made by Senator Gaines. Is there a second? Second by Member Vasquez. Let's call the roll, please.
Actually, no, Madam Chair, I was going to suggest if we're going to take them up together, why don't we hear the second one and just make a motion for the 2? Is that okay?
Fine with me.
Because it doesn't seem like there's an objection to them.
Doesn't seem like an objection at all. So what we'll do, okay, so we have an open motion.
Yeah. Well, didn't get a
Decide-
second anyway, so let's just move forward, right?
Right, there was no second. It's just an open item. So let's go ahead and call the next item, and then we will take a vote on. We'll create a motion for both items.
All right, thank you, Ms. Chairman Cohen. The next item is F1E, roll change, 2021 board roll of private railroad cars. As these matters are constitutional function, Ms. Stowers is not participating in accordance with Government Code Section 7.9. This matter will be presented by Mr. McCool.
Thank you, Ms. Taylor. Again, Chair Cohen and members of the board, Jack McCool, State of Assessed Properties Division Chief, just for the record. Revenue and Taxation Code Section 11426 allows for the correction of errors to the private railroad car roll. Before you today for your consideration and adoption is one change to the private railroad car roll. The change is being recommended to correct a staff error that resulted in incorrect application of a penalty for late filing of the property statement. Thank you for your consideration of this matter. I'm available to answer any questions if the board has any. And I ask for the board's adoption of this roll change. Thank you.
Okay, thank you. So let's go ahead and take public comment on this, and then we'll wrap up both the motion for both these items.
Certainly. AT&T moderator, please let us know if there is anyone on the line who would like to make a public comment regarding this matter.
Yeah. Or do we have that, or is it on Ted's email?
It's in, I'll forward it to you. I can't.
Someone needs to mute their mic. I'm sorry, not sure who it was. Great, thank you. Ms. Taylor, I'm sorry.
No one
please
has
continue.
queued up.
No one's queued up. All right, thank you. All right, Mr. Vasquez, can you go ahead and make a motion for both items?
Sure. I move that we adopt the 2 items as staff recommended, as their recommendation.
Second.
All right, so motion made by Vasquez, second by Gaines. Let's call the roll. Oh, well.
The motion on the floor is to adopt the audit findings and adopt the board roll change as recommended by staff. Chair Cohen.
Aye.
Vice Chair Schaefer. Vice
I think
Chair
you're
Schaefer.
muted.
Yes.
There you go.
Aye.
Member Gaines.
Aye.
Member Vasquez.
Aye.
Ms. Stowers not participating. The motion passes.
Great, thank you.
Thank you.
Ms. Taylor, let's call the next item.
The next item is J1, Administrative Consent Agenda, Retirement Resolutions for Andrew Andy B. Austin and Barry W. Fraser.
Okay, colleagues, we're going to take a 5-minute recess, and then we'll take up the next item. Thank you. let's reconvene. It is 11:38 exactly. And we left off, we just called item J1, administrative consent agenda, retirement resolution. So at this time, what I'd like to do is I want to congratulate Mr. Austin and Mr. Frazier for their dedicated service, not only to California, but also to the Board of Equalization. Let's see, Ms. Fleming, is there any remarks that you'd like to say?
Just on behalf of the agency, we are very proud and extending our congratulations to both Mr. Andrew Austin and Barry Frazier, who have just been rock stars in the organization, serving us well for a number of years. Again, we wish them congratulations in this next chapter of their life and appreciate all that they've done for the Board of Equalization and to this great state of California. So, Madam Chair, thank you for the opportunity to comment. Congratulations, guys.
Absolutely. Thank you. Colleagues, are there any comments that you'd like to say?
Madam Chair, if I could?
Please, yes.
Yes, I would also like to add my sincere congratulations to both Andy and Barry for their very valuable service, not only to the board, but to the Board of Equalization as a whole, for your tremendous contributions towards fulfilling our BOE mission over these years. And wish you nothing but the best and healthy and enjoyable retirement moving forward. And once again, I have to say I'm jealous.
There's many more years of work ahead of you, Mr. Vasquez.
I know.
Mr. Gaines, I see your hand.
Yeah, I just want to also thank Mr. Frazier and Mr. Austin for their many years of dedication to the BOE, and thank them also for the transition too, because there were a lot of changes that occurred in the BOE as a result of AB 102. And so I'm glad that they were able to hang on and keep the institutional memory within our agency. And I just wish them the best in retirement. So thank you for your service.
All right. Well, we will keep moving. Ms. Taylor, please call the next item. Or I guess, do we need to take public comment on this? There's no action.
I don't think we need to take public comment.
I didn't think so. Okay.
Our next item is J2, Administrative Consent Agenda, Approval of the Board Meeting Minutes. The minutes of the January 23rd, 24th, 2022 were attached to the public agenda notice for your consideration.
Thank you. Colleagues, are there any corrections to the minutes? All right, seeing none, members, would anyone like to make a motion on this item?
I move to approve them.
Second.
All right.
Notify.
All right, thank you. We'll hold this motion. Let's go to public comment.
AT&T operator, can you please let us know if there is anyone on the line who would like to make a public comment regarding this matter?
Thank you. No one has queued up.
Great, thank you so much. All right, so a motion has been made by Commissioner Vasquez, or no, not Commissioner, Board Member Vasquez. And it was a motion was made by who? By Ms. Stowers. Let's do a roll call vote, please.
The motion is to adopt the minutes for January 23rd, 24th. Chair Cohen.
Aye.
Vice Chair Schaefer.
Aye.
Member Gaines.
Aye.
Member Vasquez.
Aye.
Deputy Controller Stowers.
Aye.
Motion passes. If I may, Chair Cohen, I believe we do need to take a motion on adopting the retirement resolutions and therefore take public comment. So if someone wants to make a motion, we can.
So moved, Member Gaines.
All right, Member Gaines has made a motion and Member Vasquez has made a second. Let's do the roll on that.
Let me call for public
Well, you
comment.
need to take public comment, I think, first, no?
Yeah.
Yes.
AT&T moderator, please let us know if there is anyone on the line who would like to make a public comment regarding this matter.
Thank you. No one has queued up.
This Member Gaines, I'd like to make a motion for the resolutions for Mr. Frazier and Mr. Austin.
I'll second that motion. All right, so Ms. Taylor, did you get that motion? Senator
Yes,
Gaines
I
made
did.
a motion. I second that motion. And I don't believe we need to take roll. So could you please call the roll for the vote?
Chair Cohen,
Aye.
Vice Chair Schaefer,
Aye.
Member Gaines,
Aye.
Member Vasquez,
Aye.
Deputy Controller Stowers.
Aye.
The motion passes.
Thank you,
All right.
members.
Next item, please.
The next item is K1A, Executive Director's Report, Organizational Update, Report on the status of pending and upcoming organizational priorities. This matter will be presented by Ms. Fleming.
Thank you, Ms. Taylor. Good morning, members. Good morning, Chair Cohen and honorable members. I'm Brenda Fleming, the Executive Director. Just a few comments for you today to make sure that you're kept informed. The first item is regarding the status of our public meetings. The second item I'll give you an update on, members, is an update on the Advisory Council. And then finally, just some highlights on upcoming meetings of note. As you may recall, members, Assembly Bill 361 extended the ability of public agencies to meet remotely during the COVID-19 pandemic. That bill, members, is still in effect. Therefore, we'll continue to meet remotely via teleconference through March of 2022. There is legislation that was recently introduced by Assembly Bill 1733 by Assemblymember Quirk, introduced that could extend the time frame for remote meetings. However, as this bill was just introduced, we will monitor for updates, and absolutely, members, will make sure that you're kept informed. My second item is to inform you that our next Advisory Council meeting is scheduled for Monday, February 28th. I look forward to sharing the highlights and the takeaways from that meeting to add to our list of very important modernization and improvement priorities. Finally, members, as we look at the year ahead and times ahead, I'd like to highlight a few of the important dates on the horizon. In April, the 2022 Central Southern California Assessors Association Annual Conference will convene in Pismo Beach. In June, the California Taxpayers Association, CalTax, is hosting their 96th annual meeting, and that will be in Sacramento. Tentatively, as you know, members, in October, we will hold our annual meeting with the assessors, more details to come. And then finally, members, in November, the 120th annual CAA conference, California Assessors Association conference, will be held. I'll make sure, members, that you have the detail regarding these dates and locations and any other upcoming important dates or events. If there are no questions at this point, members, I'd like to turn it over to the wonderful staff who will give you updates on the operations.
Mr. Vasquez, oh, sorry, Mr. Schaefer, I see your hand. Go ahead, ask your question.
There is a June event, that's the California Taxpayers Association in Sacramento.
That is correct, yes, sir.
Right. I'd like to get back to Sacramento sometime. Right now, our authority expires in March.
Correct.
So if there is no extension, we know that we will be going to Sacramento for June.
I'll circle back with you as we get closer to that date to ensure what the travel plans can be. So you've got some flexibility, and I can certainly circle back with you, sir.
Is there some experience in government that members do go to Sacramento for part of the year, if not for the difficult months, say when the pandemic is strongest? I just am not happy with never going to Sacramento.
And we miss you in Sacramento, but Chair Schaefer for sure. But again, as it relates to our public meetings, and that's where we're making the distinction, it's a public meeting for state agencies, and that legislation is speaking to what we're able to do in terms of public participation and holding our meetings in person. As it relates to the CalTax events, that's not a public meeting, it's not a government public agency meeting, and so the rules might be a little bit different for them. At this point, they're just announcing the time frame of their meeting. We'll work with them to get more details to make sure that you're informed, sir. You're muted, sir. I'm sorry.
Oh, that we're in Sacramento the same time they're meeting, so it'd be convenient for us
That would,
to.
that would be
Thank
good.
you.
More details to come. Thank you, members. Madam Chair, I'll turn it back over to you.
I appreciate that. Thank you. All right, colleagues. Well, I guess, Ms. Executive Director, does that complete your report?
That completes my report. If you, with your permission, ma'am, we'll have Ms. Taylor continue with the rest of the presentation.
All right, just a second. I think Vasquez has a question.
Just a quick, I always just want to thank you for your updates, and actually kind of looking forward to your report. I guess it's going to happen in March now on the advisory council meeting.
Yes, sir.
Thank you.
Thank you. Madam Chair, with your permission, Ms. Taylor.
Yes, please continue.
Okay. Yes, we will need to take public comment. AT&T moderator, please let us know if there is anyone on the line who would like to make a public comment regarding this matter.
Thank you. No one has queued up.
Thank you. The next item is K1B, Executive Director's Report, Operational Priorities and Projects. Operational Priorities, report on the status of operational priorities. This matter will be presented by Ms. Renati.
Good morning, Chair Cohen and honorable members. I am Lisa Renati, Chief Deputy Director. Today I will report on some of the agency's operational priorities and projects. The first item is our workforce capacity. Since our last meeting, we have filled 4 positions. 2 were internal promotions and the other 2 were filled with staff new to the agency. The team continues to focus on this important effort to ensure our workforce capacity is solidly in place. The next item I would like to present is an update on our process improvement project. As I have mentioned in past reports, process improvement is a proactive and continuous process with examination of the processes and procedures of each unit and determining how to best improve each process for workflow, relevance, and user experience. This project aligns with the agency's strategic plan goals to modernize our tax administration functions and provide for the growth and development of our future property tax leaders. I'm happy to report that while the work is being performed in addition to our regular duties, the process improvement project continues to advance and progress is being made. Later this morning, you will hear a report from Ms. Lauren Keach, a manager within our County Assessed Properties Division, who will talk about the specific progress on the welfare exemption supplemental clearance certificate process, and we will continue to inform the board of any other notable improvements and our processes and procedures. This concludes my report on some of the agency's operational priorities. I'm available to answer any questions you may have.
Well, thank you. Let's see if there's any questions for Ms. Renati. Colleagues, this is a pretty straightforward presentation, so it doesn't surprise me that there isn't any. Let's go ahead and take public comment.
AT&T moderator, please let us know if there is anyone on the line who would like to make a public comment regarding this matter.
No one has queued up.
All right, great.
Thank you.
Let's take a vote. Or, yeah,
We'll
let's take a
move on.
vote.
Yeah.
We'll move on. You're right, no vote. Let's just move on.
Thank you. The next item is K1C, Executive Director's Report, Proposition 19 Implementation Project, report on the status of the agency's Proposition 19 Implementation Project. This matter will be presented by Ms. Renati.
Good morning again. This is Lisa Renati, Chief Deputy Director. Today I will provide an update of our Proposition 19 Implementation Project. A high-level implementation plan is attached to today's agenda. I'm happy to report the status of our Prop 19 project is green, which indicates we have no issues or concerns to report. Members, next, each team leader will provide you with a specific information on the implementation actions for each of their areas. Thank you.
Colleagues, any questions? Again, really simple, straightforward. All
This
right.
is Mr. Gaines, if I could, just briefly.
Yeah, Mr. Gaines, go ahead.
Yeah, I just wanted to thank Ms. Renati on basically everything she's reported on. I think organizationally, I'm just really happy how things are going in terms of getting to, full staffing. And we've made so much progress. Just very encouraged by that. So I just wanted to highlight that. Thank you.
Thank you, Member Gaines. It's a team effort. I can't take any credit for how well my team has done, but they're doing a tremendous job. Thank you.
Yes, all of you are. So thank you.
Great. Seeing no other hands, let's go to public comment.
Chair Cohen, perhaps
Yeah.
we can go through the sub items and then we can take public comment at the end.
Sure.
Okay. The second sub item is the Property Tax Department's Prop 19 implementation and guidance presented by Mr. Young.
Yes, good morning, Chair Cohn and honorable members of the board. David Young here, Property Tax Deputy Director. I am going to give you a brief report on our department's implementation of Prop 19. So the biggest news I have for today is that we have released our long-awaited LTA giving guidance on the base year transfers. As you will recall, SB 539 went ahead and put into statute 69.6. This is a LTA that will give additional guidance to the ones that we already have out on the implementation and the administration of that base year transfers. So that was released as of Thursday of last week. So February 17th, it was actually put on our website. Just as a brief note, that actually is the 14th LTA that we put out on Prop 19 and its various aspects. What's next on the agenda is an LTA on the intergenerational transfers that has already gone through development, and we anticipate it being released as early as tomorrow. So that will make it number 15 of our LTAs on this issue. What else is going on? Staff continues to work on reviewing guidance, LTAs, old annotations on this issue. We're identifying any LTAs or any written guidance that needs to be updated or depublished. We are also working on updating 10 forms to conform with SB 539. And we are continuing actually a pretty good, decent workload on answering public inquiries on this issue. Okay. So we're still getting a lot of calls from taxpayers, from assessors, other stakeholders on the application and the implementation of Prop 19. So this will conclude my presentation for the Property Tax Department. I'm available for any questions you may have.
Colleagues, any questions for Mr. Young?
All right, the third. Oh,
I have a question, Madam
Please,
Chair.
Ms. Stowers, go ahead.
Mr. Young, where do we stand on the system change? Aren't we supposed to be tracking?
Yeah, thank you very much, Deputy Controller, for that question. Our system change is actually complete. We have designed and implemented a system to track the base year transfers, and so it's complete. Thank you to staff and our partners in CATFA. They've been a fantastic resource in helping us do that. So it is up and running, and we've actually had reports come in already.
Perfect. Thank you.
Of course.
All right. Glad you got your answer. Any other questions for Mr. Young? All right, let's hear the third sub item.
Certainly. The third sub item is Legal Department's Proposition 19 implementation and updates presented by Mr. Nanjo.
Thank you, Kathy. Good morning, Chair Cohen, honorable members of the board. I am Henry Nancho, Chief Counsel of the BOE's Legal Department, here with my senior counsel, Richard Moon. As I reported last month, the legal department completed the initial rulemaking effort to implement Proposition 19. Additionally, as the board knows, Senate Bill 539 was signed into law by the governor on September 30th, 2021. SB 539 provided amendments to the Revenue and Taxation Code sections 62.3 and 69.6, clarifying Proposition 19's constitutional amendments. Since SB 539's passage, staff has been working closely with the Property Tax Department to review the board's Proposition 19 related property tax rules in light of SB 539. Staff has determined that both of the board's Proposition 19 related property tax rules will require amendments through the emergency rulemaking process to fully implement SB 539. Today, I will provide status updates and our anticipated timeline to initiate each emergency rulemaking action. For Property Tax Rule 462.540, exclusion from change in ownership, base year value transfers, which implements Revenue and Taxation Code 69.6, staff is currently drafting amendments and anticipates presenting the proposed emergency rulemaking package for the board's consideration at the March 2022 meeting. For Property Tax Rule 462.520, exclusion from change in ownership intergenerational transfers, which implements Rev and Tax Code Section 63.2, staff is in the early drafting stages and anticipates presenting the emergency rulemaking package for the board's consideration in April 2022. We will keep the board updated with any changes to this anticipated timeline. I'd like to thank my team for being very active in helping partner with the Property Tax Department and answering public inquiries to clarify all these changes Proposition 19 has brought upon us. That concludes my report. Please let me know if there are any questions at this time.
Thank you, Mr. Vasquez.
Yes, Mr. Andrew, you kind of touched on it, and I was wondering, do we have like a good estimate of when your office expects to have that taxpayer information sheet on SB 539?
I believe that's being worked on both with TRA and in conjunction with the Property Tax Department. That is one of the priorities, so we are currently working on getting that out. I don't have a current timeline, but it is a priority project as well.
And actually, I wasn't sure if it was something you're kind of spearheading, or is that Ms. Thompson? Is that something I should ask her later? Or?
Yes, the information sheets typically come from the TRA office.
All right, I'll wait then. Thank you.
Thank you, Chair. Thank you, Member Vasquez, for that question. Any other questions, members?
I don't see any.
Great, thank you very much.
Thank you. Let's go to the fourth sub-item.
The fourth sub-item is update on legislation related to the implementation of Proposition 19, presented by Mr. Weatherby.
Good afternoon, Chair Cohen, Vice Chair Schaefer, and honorable members of the board. This is Dustin Weatherby, Chief of the Legislative Research and Statistics Division. So after the legislative bill introduction deadline on Friday, no bills were introduced or amended relating to the implementation of Proposition 19. While no new bills have been introduced or amended, Assembly Constitutional Amendment 9 by Assemblymember Kevin Kiley is still pending in the legislature. The last day for the legislature to place a measure on the November 2022 ballot is June 30th. So this particular measure seeks to repeal several provisions of Proposition 19 regarding intergenerational base year transfer exemptions and instead reinstate the prior rule. This measure would apply retroactively to all affected purchases or transfers occurring on or after February 16th, 2021. Currently, ACA 9 is awaiting referral to a committee in the Assembly. So this will conclude my presentation on this item, and I'm available to answer any questions.
Questions for Mr. Weathersby? All right, I don't see any. All right, thank you. Colleagues, let's keep moving. Let's hear the fifth sub-item.
The fifth sub-item is Communications Office Proposition 19 Implementation Actions, presented by Mr. Kim.
Thank you, Ms. Taylor. Good afternoon, Chair Cohen and honorable members of the board. This is Peter Kim, Chief Communications Officer. Members, today I'll provide a brief report on the Communications Department's efforts in implementing Proposition 19. Members, as you know, the Proposition 19 webpage is being updated and enhanced to provide the latest information in real time for stakeholders and taxpayers. Since last month, a notable update includes adding the letter to assessors on the implementation of Proposition 19 base year value transfers. This LTA was also highlighted on our social media channels to let our followers know of the new guidance. Also, the taxpayer rights advocate Lisa Thompson and I have been collaborating together to update the existing Proposition 19 fact sheet to reflect the changes due to SB 539. We will inform the board and the public once the fact sheet is finalized. As of yesterday, we received a total of approximately 280,504 unique external page views since November 10, 2020. Since my report at last month's board meeting, that's an additional 11,709 unique external page views. Finally, we're continuing to use our social media channels such as Facebook, Twitter, Instagram, and LinkedIn to expand our audience and direct followers to the BOE website for the latest updates and resources. This concludes my report, and I'm available to answer any questions the board may have.
All right, I don't see any. Hold on, Senator Gaines, I see your hand.
Great, thank you. I just wanted to highlight again the number of page views as it relates to Prop 19. So, Mr. Kim, you had mentioned that it's 280,000, and I think you've been tracking that on a monthly basis. I'm just trying to get a handle on, is that waning off? I mean, are fewer people viewing that per month, or is it stabilized, or is it going up?
It's pretty, thank you for that question, Board Member Gaines. It's been pretty consistent. The range has been between 11,000 to about 15,000 per month. And so I think as we issue more and more guidance due to the passage of SB 539, we're anticipating more visits to the webpage. As Mr. Young has alluded to, the Property Tax Department's contacts that they've received have been pretty consistent, and the volume has been pretty solid. So we're anticipating that the views to our web pages are also going to be similar.
That's great. Well, I want to thank you just for providing that information and working on enhancing our website, because it's such a critical tool in terms of our ability to communicate with our constituents. Thank you.
Thank you.
All right, thank you. Let's see.
Thank you, Madam Chair.
I see no other hands, so let's go to the sixth and final sub item.
The sixth sub-item is the Taxpayer Rights Advocate Office implementation of Proposition 19, and the seventh sub-item, Education and Outreach for Proposition 19, is presented by Ms. Thompson.
Good afternoon, Chair Cohen and honorable board members. I am Lisa Thompson, Chief of the Taxpayer Rights Advocate Office. I'm pleased to report on the Proposition 19 implementation and action plan for the Taxpayer Rights Advocate Office. The Taxpayer Rights Advocate Office implementation plan is focused on developing new information sheets for the intergenerational exclusion and base year value transfers under Proposition 19 and revising its existing information sheets affected for this change in law. Our office has reviewed the language in Proposition 19's implementing legislation resulting from Senate Bill 539 and has reviewed information issued by our agency's Property Tax Department concerning this implementing legislation. Last week, Letters to Assessors 2022-09 was issued addressing the base year value transfers, and as the Property Tax Department just indicated in its report, the LTA pertaining to intergenerational transfers will be issued this week. Our office is collaborating on how best to present information on Proposition 19, its implementing legislation and LTA guidance in the Taxpayer Rights Advocate Office information sheets so that taxpayers are aware of property tax savings available to them. Our information sheets will identify the effective dates for Proposition 19 when implementing legislation was passed, as well as key LTAs issued by our agencies concerning the implementing legislation. I'll go ahead and go on to the next item if that pleases the board. Again, I'm Lisa Thompson, Chief of the Taxpayer Rights Advocate Office, and I'm pleased to report on the Proposition 19 implementation and action plan for education and outreach. The Proposition 19 implementation and action plan for education and outreach is focused on creation of a Proposition 19 fact sheet and presentation material development. As you know, we issued a Proposition 19 fact sheet and PowerPoint presentation on February 1st, 2021. And our office has collaborated with the Communications Officer, Peter Kim, on updates to this Proposition 19 fact sheet that we issued in February as a result of implementing legislation from Senate Bill 539 that was signed into law September 30th, 2021. And we have also reviewed information issued by our agency's property tax department on this implementing legislation. We have prepared a draft of the revised Proposition 19 fact sheet incorporating information from implementing legislation and corresponding guidance on this issued in the 2 letters to assessors on this implementing legislation for base year value transfers and intergenerational exclusions. The revised fact sheet is currently being reviewed internally, and once that is finalized for publication, once the internal review is completed, we'll apprise you at a later board meeting of the fact sheet's in status to keep you informed. Later in the agenda, I'll be providing some information on the activities of the TRA office as to issuance of the TRA annual report and projects being worked on, as well as some statistics on completed cases. This concludes my update for the Education and Outreach Implementation Plan. I am available to answer any questions.
All right. Thank you, Ms. Thompson, for just continuing the excellent work and the excellent work that your staff is doing, particularly during these really difficult times. As we see from the TRA annual report, your office provides great assistance to taxpayers so that as they attempt to navigate the complex property tax system. I know that all these cases are not cookie cutter cases. And each inquiry is different. Each requires a great deal of expertise to provide the appropriate and accurate and also timely responses. So I was wondering if you had a need how many staff members do you have in your office to help with these inquiries?
There, including myself, there are 4.
Okay. All right. Okay. Well, let me compliment you on including a breakdown in your report on how taxpayer cases in the valuation category differ from the cases in the administrative category. I thought that was great.
Thank you. I appreciate that. And I'm happy to, and thank you so much for that. And I'm also I'm pleased to expand more on the details of the taxpayer rights annual report in item K5 at that time. So
okay, please do
if we could. Okay.
Yeah, go ahead.
Ms. Cohen, we are on item K1C.
Oh, we're still on 1C. Sorry, I'm jumping the gun.
Okay.
I just saw Ms. Thompson. I got excited.
I understand. Would you like me to call for public comment so we can?
Yes, I would.
Ms.
Thompson, we'll circle back to you because I have.
Thank you. It's an exciting report. I'm glad
it is an exciting report. Okay, go ahead.
AT&T moderator, please let us know if there is anyone on the line who would like to make a public comment.
Once again, if you would like to make a public comment, please press 1 then 0 at this time. Currently, we have nobody queuing up.
Okay, thank you.
The next item is K3A, Property Tax Deputy Director's Report, Operational Updates, Report on the status of pending and upcoming projects, activities, and departmental issues. This item will be presented by Mr. Young.
Yes, thank you, Kathy. Good afternoon, Chair Cohn and honorable members of the board. David Young, Deputy Director of the Property Tax Department here again. For you today, I will have an update on what's going on in the Property Tax Department. So as a whole, as Ms. Renati mentioned, the Property Tax Department is doing really well, and we are making great progress on our process improvement project. Right now, we have much of our processes already documented, and we are identifying ones that have not been documented in the past, and we're working on that. So staff has been very busy and doing fantastic work on that. In the CAPD, the County Assessed Properties Division, much work still continues with Prop 19, as we mentioned earlier. We are still getting a fair amount of inquiries coming in, and it is taking staff, it's taking up a lot of staff time. Ms. Lumsden will follow after my presentation. We'll give you additional updates on 3 of our main functions in CAPD, so that will follow. In SAPD, the State Assessed Properties Division, much of the work now concentrates in getting ready for the 2022 evaluation season. So right now, staff is finishing up with their capitalization rate studies and is in the process of reviewing their appraisal templates, their methodologies, and everything it takes to start the appraisal process. So come March, our season will be in full swing and staff will be working double time to get everything completed and to the board by May. And with that, this will conclude. Oh, I'm sorry, there's one more thing. Ms. Keith will also, Ms. Keith will also provide you a little bit more detailed update on our process improvement project as it relates to the welfare exemption. So that will also follow. I'm available for any questions you may have, and if not, I will turn it back to Ms. Taylor to go ahead and call for the next 5 presentations.
Thank you. The next sub-item is letters to assessors presented by Ms. Lumsden.
All right, just for clarification and for our staff, I'm gonna continue moving forward, but we're gonna break at 12:30. That's in 15 minutes, and then we will have a lunch break and we will resume at 1 o'clock. So let's continue with the letters to the assessors, but just note to the members of the public and my colleagues that we're going to break at 12:30 in 15 minutes. Okay, let's continue. Thank you, Ms. Taylor.
Good afternoon, board members, Chair Cohen, and honorable board members. This is Patty Lumsden. I'm Chief of the County Assessed Properties Division. Today, I will provide you with a brief report on letters to assessors. Attached to the agenda this month is a memo on letters to assessors, which provides a list of the LTAs that have been issued since our last board meeting. In addition, it provides a link to the BOE's website where a list of all LTAs can be found that have been issued to date. The LTA memo attached to the agenda this month shows that BOE staff have issued a total of 9 LTAs for calendar year 2022, and 5 of those have been issued since our last board meeting. And I will provide you with a brief summary of each of those 5 LTAs. The first LTA, which following a public hearing announced the board's adoption of property tax rule 462.540, change in ownership base year value transfers. This new rule was approved by the Office of Administrative Law and became effective on January 1, 2022. The next LTA provides the amendments to Revenue and Taxation Code Section 277 per Senate Bill 667, which added subdivisions B and C to Section 277, expanding the authority of who can file a claim for the disabled veterans exemption with the assessor, and now includes the executor, administrator, or personal legal representative of a claimant's estate, or the trustee of the deceased claimant's trust assets. The next LTA, which was presented in its drafted form and adopted by the board members at the last board meeting. This LTA provides general principles to guide and assessment appeals boards and local boards of equalization when holding remote hearings. This LTA supersedes previous guidance issued under LTA numbers 2020-057, 2020-063, and 2021-002, and a notation has been placed on each of these prior LTAs, which shows on our website to indicate that they have been superseded by this new LTA. The next LTA provides a report on the 2021 State Assessed Property Appeals, which lists those assessees whose original board adopted value was revised upon appeal, the revised amount, and the counties impacted, as well as those assessees whose original board adopted value was not adjusted upon appeal. And finally, the last LTA provides further guidance on the implementation of the base year value transfer provisions under Proposition 19 after the passing of Senate Bill 539, which added Section 69.6 to the Revenue and Taxation Code. This concludes my report on letters to assessors, and I'm available to answer any questions you may have.
Okay. Mr. Vasquez.
Yes, thank you, Madam Chair. And thank you, Ms. Lumpson, for for your staff's excellent work, especially on these LTAs. I have two questions for you. The first one relates to the LTA number 2022/06. States that the trustee or the executor can now sign a claim for a disabled veteran's exemption. But I have many veterans in my district with questions about the value of the veteran's exemption versus the homeowner's exemption. And I'm wondering, actually basically been advising them that they cannot claim both the homeowner's exemption and the veteran's exemption. But I'd like to direct them to a link on our website that answers their questions on which one will provide the biggest exemption amount. It seems like the veteran's exemption is less, unless I'm reading that incorrectly. Do we have a fact sheet or a simple LTA on the monetary differences between the exemptions and basic qualifications?
So thank you for that question, Mr. Vasquez. So we do have on our website information regarding the exemptions. This particular LTA that I'm just brought up has to do with the disabled veterans exemption, which is different than the veterans exemption. So the homeowner's exemption is a $7,000 exemption, and the veterans exemption is a $4,000 exemption per year. So that's the difference between the two. That, of course, there's other requirements as well and qualifications involved, and most people do claim the homeowner's exemption over the veterans exemption because it is a higher dollar amount in terms of giving relief. But the disabled veterans exemption is different than those two exemptions. So, and then we do have on our website information about the disabled veterans exemption, as well as information on the homeowner's exemption and the veterans exemption.
Thank you. And then my second question is, in the new LTA 2022/012 on the intergenerational transfer exclusion under Prop 19, I noticed that if a transferee is no longer qualifies for either the homeowner exemption or disabled veterans exemption, the exclusion is removed and the value of the family home is re-enrolled back to the date of change in ownership. How and when will transferees be notified of this before they get this big bill? And will the notice give the transferee a chance to take corrective action and reapply for the exemption?
Well, thank you again for that question. That particular letter to assessors hasn't been put out for this report that I put out. It must have recently come out or is about to come out any day, I believe. But in regards to your question, the taxpayers would be notified through I'm assuming some sort of notification of the removal of their homeowner's exemption. I would believe at that time, that's something though that the assessor's office would be responsible for handling. And so how they would be providing those notifications would depend upon what exactly transpired to cause that to be removed. But they would be notified because any change in the assessment does require notification to the taxpayer.
So that responsibility you're saying is really put on the county assessors in each respective county then?
Yes, that is correct.
I'm a little worried about that because I know LA being so huge, I'm wondering if they have the people power to make sure that gets out. We have no way of tracking or providing assistance on that, especially I'm thinking to the large counties.
Yeah, that providing the notification to the taxpayers on their assessments or changes in assessments, that is at the local level. That's not something that the Board of Equalization does.
All righty, thanks.
You're welcome.
Colleagues, I don't see any other hands. Are there any other questions for Ms. Lumsden? Okay.
The next sub item is appraisal, training, and certification presented by Ms. Lumsden.
Thank you, Ms. Taylor. Again, my name is Patty Lumsden. I'm the Chief of the County Assessed Properties Division, and I will now give you a brief report on the BOE's appraisal, training, and certification program. Since our last meeting, we have taught 2 more virtual classes of our most requested courses, And so far during calendar year 2022, we have taught a total of 4 virtual classes and trained a total of 134 students. And to put this into perspective for you, last year at this time, we were still trying to get our classes converted over to a remote learning format and up and running. So we had not taught any classes during the first 2 months of 2021. So this puts us on track to outsurpass what we were able to accomplish last year, and I'm looking forward to meeting that goal. And that will conclude my report on training and certification, and I'm available to answer any questions you may have.
Mr. Vasquez, I see your hand, and I see yours, Mr. Gain.
Yes, thank you, Madam Chair. Just one quick one. I believe these virtual classes are here to stay and are the only way to reach most students with minimal effort and the logistics of it. What is the department's plan to increase capacity, either with more classes, more subjects, or with more instructors, so that we can increase the number of people trained and certified?
Thank you for that question, Mr. Vasquez. We are working on that as we speak, in terms of trying to expand our ability to teach more classes. I've made mention in several of our board meetings that we are planning on doing a hybrid once we are able to, and we will do some remote classes, and we will also try to go back to doing some in-person classes. All of the classes differ in the information that's in them and presented in them. So some classes do or may fare better for the students being held in person. We're kind of finding that out as we're going through this process, and other classes may be great for doing remote learning. And it also assists with not only saving BOE staff having to travel around the state to accommodate these assessors and their staff, but it also helps the assessors in being able to send their students to the different locations that we will be able to teach at. We do teach at multiple locations throughout the state when we do have in-person training, but obviously we can't meet every goal of being in every county. So we definitely choose our positioning in accordance to locations and trying to meet the needs of as many assessors and their staff as we can. That being said, we do plan on expanding the number of classes we're offering, and also we have already discussed expanding the number of students allowed in the class. We're finding now that we're getting the hang of doing more of the remote teaching. It's allowing us to expand that a little bit more. And but to keep in mind that even though these are being held remotely in a virtual format, it still requires a lot of personal relating to the students, and it's very difficult to do if there's 100 students in a class that has a lot of mathematical calculations in it. So we really can't expand it too much, because it still requires us to be able to make time for the students and be able to answer their questions and work with them after hours and stuff and with the class as well. So hopefully that answers your question.
Yes, I think so, because it sounds like you're obviously working on trying to be a little bit creative given the situation and basically which we're learning given this virtual new, I guess, way of thinking and operating. And it looks like you're getting a pretty good handle on it. Appreciate it.
Yeah, thank you for those comments. And yes, we have been working on this. We do our classes in a fiscal year. And so we are finishing up the current fiscal year, and we'll be meeting together to start setting up our plans for the coming fiscal year.
Thank you.
So it appears that depending on the topic, in-person classroom experience might just make more sense, just might be more appropriate.
Yes, that's what we're finding, and that's what we're making note of to try to be able to accommodate the assessors and their staff as much as we can. Because of the more difficult the classes and the more mathematical calculations that are involved, we're finding it's difficult to teach that in a virtual format.
Okay. Mr. Senator Gaines?
Great. Yes. Thank you, Chair Cohen. I just wanted to ask Ms. Lumsden if she could present just a small graph for us, or a chart for our next board meeting. it'd be very helpful, I think, for all of us to know how many people we're teaching and training each year. So you had mentioned that we're already ahead of the curve for the first 2 months of this year with 134 students in 4 classes, and that's awesome. But it'd be really helpful for me to know what were we doing before the pandemic, what happened during, and what's happening now. Because I'm making the assumption that we are providing more classes to more people than we were before the pandemic. And I just don't know if that's accurate, but it'd be nice to see some data.
Certainly, we can look into providing something like that for the next board meeting. I did at our last board meeting provide you with statistics on how the differences between years 2017 to the current year 2021. So to try to give you a good perspective, but we can definitely look into seeing if we can provide you with a graph of that information.
Well, if you've already done it, let's don't reinvent the wheel. If I've already requested it, I apologize.
Oh, no, not a problem. I just wanted to mention that we did bring that up at the last board meeting, the statistics for those classes.
Okay. Maybe what you could do is I could review those individually with you. So, because I can't recall what those are. I'm sorry.
I have them. If you would like me to go over them,
yeah, please do.
Like. So in 2017, we taught a total of 23 classes with 644 students, and we used 16 BOE instructors to teach those classes, and we also used 7 county instructors.
Okay. All right.
Then in 2018, we were in the process of change, having gone through the switch over from the breaking off with the CDTFA part of our agency. And so in 2018, we only had one BOE instructor and 1 retired annuitant. And so our teaching that year, we only taught 16 classes in 2018. We only taught a total of 462 students, and only 5 of those were taught by BOE instructors. And we partnershiped with 11 county assessor staff to teach the other classes for us.
Okay.
So in 2019, we started ramping back up our program again, and we taught 22 classes that year. We taught 636 students, and we had 14 of them were taught by BOE instructors and 8 taught by the county instructors.
Okay.
In 2020, that's when we had the pandemic, and the pandemic hit us, and that year we were only able to teach 6 classes in person, total number of 176 students, and 4 of them were taught by BOE instructors and 2 of them by county instructors. And then that's when we were shut down and we could not teach any classes for the whole rest of that year. And so then in 2021, we spent the first 2 months trying to get our in-person classes up and running because we hadn't been able to teach them for so long. And we once we saw that the pandemic wasn't going anywhere, we needed to put in place some type of ability to continue teaching these classes. And so we came up with doing the remote virtual learning process. And so that year in 2021, we were able to teach a total number of 18 classes and 578 students, and all 18 of those classes were taught by BOE instructors, which was the first time that we've taught all our own classes. So the remote virtual learning actually did give us that ability to teach all of our own classes without having to partnership with the county assessors staff. And so that, we're doing a lot of learning from the whole process of doing remote learning. And so we're finding, like I said, that a good hybrid of that process, once we're able to teach our in-person classes again, we would like to continue doing that, our virtual training classes, but we will also like to start going back to doing some in-person training as well.
Okay. That's great. Now, in 2017, was that prior to AB 102?
The AB 102, I believe, took place or went into effect on July 1st of 2017.
Okay. All right. Very well. So we had to kind of rebuild it, didn't we?
Yes, that's exactly what we had to do. So in 2019, we started expanding our program, and that's why we were able to. We were on the verge of really revamping of that program. And we did really well in 2019, and we were on schedule in 2020 to do the same until the pandemic hit. So.
Yes, yeah, wonderful. Well, you're doing a great job, so thank you for providing that. And do you think we're satisfying the demand? I don't know what the demand is.
The demand, I can tell you, is really high right now, and a lot of it, is partly from not being able to teach classes for like 7-8 months, however long that period of time was that we were not able to teach classes. Yes. So we're trying to get those caught back up. Also, we have assessor staff that have been newly hired, so a lot of these classes are, in high demand for the newly hired staff members. So it's definitely high demand, and we're, doing the best that we can to accommodate them, but we know we need to do more, and that's what we're working on.
Great. Hey, thank you so much for that update, and apologize that I asked for it twice. So I'm glad we went through it, and I have a clear understanding, and keep up the good work.
Thank you, and I'd like to thank my staff that's involved in the training and certification program, because they're the ones doing all the work. So thank you very much for those nice comments.
Great, thank you.
All right, colleagues, it's 12:33. We are adjourned until 1 o'clock. Enjoy your lunch. Thank you.
Madam Chair, just a note, we'll recess, not adjourn, we'll recess.
Excuse me. I appreciate that clarification. You're right. We will recess.
You're welcome to adjourn too, Madam Chair, if you wish.
No, we have too much work to do. Let's just recess.
Thank you, ma'am.
Thank you.
Ms. Taylor?
Are we calling the meeting back to order?
Yes, ma'am.
All right, to refresh, we are on item K3A, Property Tax Deputy Director's Report, Operational Updates, sub-item Assessment Practices Surveys, presented by Ms. Lumsden.
Thank you, Ms. Taylor. Good afternoon, Chair Cohen and board members. This is Patty Lumsden. I'm the Chief of the County Assessed Properties Division, and I will be giving you a brief report on the BOE's Assessment Practices Surveys. Since our last board meeting and for calendar year 2022, we recently issued the following 2 assessment practices survey reports via letters to assessors. Santa Barbara County in District 2 and Alameda County also in District 2. Since these reports were issued only yesterday via LTA, they were not included in my previous LTA report that I gave earlier, but will be included in my LTA report next month. In addition to these 2 counties, we are actively working on completing surveys and samples for 10 other counties. 6 of those are in District 1, 2 in District 2, 1 in District 3, and 1 in District 4. These surveys and samples, of course, are in various stages of production, and once completed, a copy of the report is provided to each of the board members and their office for preview. Our staff continues to conduct these surveys and samples remotely, and they work closely with each assessor and their staff to determine the best way to collect the necessary information in the least impactful way to the assessor. This concludes my report on assessment practice surveys, and I'm available to answer any questions you may have.
Thank you. Colleagues, are there any questions? All right.
Just one quick one, if I may,
Okay.
Madam Chair. It happens to deal with the counties here. I'm just looking at, have any of the counties expressed their concerns regarding resources needed to provide data to us?
Yeah, so thank you for that question. So that's why we work with each individual assessor when we get ready to do our survey. We reach out to them months in advance to determine what the best way is to collect that data. And so we determine based upon what that county's particular situation is, whether or not they're able to give us remote access, or if we need to seek assistance, having them help gather the data that we request. So every county is different in what their capabilities are. And so we work with those counties to determine what the best way to collect that information is. So it's not ideal, and we definitely are looking forward to going back in person. But at this time, this is the best way for us to collect this information so we can continue doing our statutory duties.
Thank you. One last quick one.
Certainly.
It's my understanding the assessment practice survey is our way to promote uniformity and fairness and equity and integrity pretty much of the property tax assessment process. From what you have seen from the results, as a general consensus, what is the ongoing issue that you see needs work or needs to be prioritized?
So I may need a little clarification on your question because there's different things that we see in terms of there are certain recommendations that we see across the board in different counties, and we try to provide information on those recommendations. And also these reports are published for the public, and so any of the other counties also are available to see them and review them to see what sorts of recommendations we made in that particular county versus another county. So I don't know if that's what you're referring to in terms of what we see.
Yes, I think you're kind of hitting on it because, I know obviously when you're dealing with, with 58 counties throughout the state, you got the large, the medium and the small, but I was just wondering especially on those where you feel like there's somewhat of consensus on what you think might be some of the areas that we should be at least looking to possibly prioritize in terms of improving the situation.
Well, one of the things that we also participate in is the California Assessors Association's Survey Ad Hoc Committee, We meet with them on a regular basis and go over different issues that we see are recurring recommendations between the counties and which ones we can help be resolved and get the information out to the different counties. So we share information in that way. In addition to that, we also, like I said, we have different mechanisms of providing that information. And like one of those ways is through our published reports, and then counties can see those in an effort to see if perhaps they're having the same issues. And then plus on top of that, they can reach out to us and we can go over those issues with them.
Yeah, that's what I was kind of hitting at, because I'm assuming that some of the smaller counties are probably having a little bit of a difficult time given their limited resources, and especially under this, this whole COVID situation. But I really encourage staff to see what we can do to try to bring as many of those smaller counties into the fold as possible.
Right. So we also have been prioritizing our coming surveys in terms of handling the main topics of issue so that we can provide that information to the assessors and their staff. And then also it's a good learning tools for our own new appraisers that we have on staff. So we go over those particular topics, and we're looking more in depth at providing more training on some of the more difficult property types that we usually review, such as taxable possessory interests, CLCA type properties. And so we are looking into possibly providing more education type resources for them, as opposed to writing up recommendations on certain topics. So we're finding that may be more beneficial to the assessors and their staff, and then that would be helpful too for some of the smaller counties. And we have done that with some of the mining claim topics, and that was very successful last year when we did it, and we're looking forward to putting out some more of those sessions.
And I'm assuming because of technology, a lot of the small counties are probably, it's a bit of a challenge for them. And I don't know what we could do on our end in terms of assisting with some of those resources or training.
Right. So that is, like you said, that is something we're working on putting in place. And we also have staff dedicated, our assessment services unit is dedicated to assisting not only the public in answering questions, but they also answer questions for assessors and their staff as they come across some of these more complex issues as well.
Thank you.
You're welcome.
All right, seeing other questions, let's keep moving forward. Ms. Taylor.
Our fourth sub-item is state assessed property presented by Mr. McCool.
Good afternoon, Chair Cohen and honorable members. My name is Jack McCool, Chief of the State Assessed Properties Division. Today, I will provide information on the status of ongoing work in our division. Staff are working diligently on compiling data for this year's annual capitalization rate study. Appraisers with knowledge and expertise in each of our industry groups have been compiling the market data used in the study and are now in the midst of analyzing the data. Staff have also started meeting as a larger group to scrutinize each other's industry data, and we will hold a series of internal meetings over the course of the next couple of weeks before publishing the study in early March. As always, staff have been engaging with state assessees and have received input from several assessees. We will continue to make ourselves available to any assessees that would like to share any data or thoughts on this year's study. I am happy to report that staff have made good progress compiling the other main factors used in our annual appraisals. Staff have published this year's condition % good factors, which are now live on our website. These factors are used in some of our cost approach value indicators and are used to help appraisers calculate the proper amount of depreciation. Staff are also working to complete this year's replacement cost new factors. These factors are also used in certain cost approach indicators. We hope to have these factors completed and placed on our website by mid-March. Finally, members, our field appraisal staff continued their lean date 2022 appraisal assignments to determine the market value of state assessed land parcels and leased and non-unitary improvements. These land values will be incorporated into the 2022 valuations. The field appraisal team uses both market data and assessee provided data to reach their value conclusions. As part of their work, this team travels throughout the state, conducting physical inspections and analysis of both state assessee property as well as market comparables. That concludes my report on the status of our division's ongoing work for this month. Happy to answer any questions if there are any. Thank you.
All right, thank you.
Thank you.
I don't see any hands, so it looks like there are no questions. Okay, Ms. Taylor.
The fifth sub-item, Welfare Exemption Process Improvement Project, will be presented by Ms. Keach.
Good afternoon, Chair Cohen and honorable members of the board. My name is Lauren Keach and I'm the manager of the Welfare Exemption section of the Property Tax Department. Today, I will provide you with an update on the Welfare Exemption Supplemental Clearance Certificate Process Improvement Project. Our goal for the project is to streamline the SEC process for claimants seeking to exempt low-income rental housing from property taxation. We have identified opportunities for improvement and ways to increase efficiency when processing SEC claims. We have completed our examination of the application process. The checklist and claim form were revised and are available on the BOE website for claimants to utilize. The examination process considered common reasons for an incomplete claim that can delay approval and incorporated discussions with taxpayers to provide insight on necessary revisions to accomplish our goal of providing a more clear and user-friendly application process. We will continue to keep record of common reasons involved in incomplete claims following the newly implemented form and make necessary adjustments to ensure the success of this component of the project. We have now moved on to phase 1 of the claims process of our project, which is to review each step of the claims reviewing process that is required to grant an SEC. In our internal analysis, we will look for ways to simplify, improve, and modernize each step in the SEC claims process. This process will incorporate a thorough review of our procedures and analysis of our available resources for taxpayers. At our last board meeting, we were asked whether our website provided FAQs on the application process for SECs. Currently, our welfare exemption webpage provides general information on the filing requirements for both OCCs and SECs and provides links to the various types of applications to be filed with the BOE, as well as samples of applications to file with the county assessors once an OCC or SEC has been granted by the BOE. In addition, our website provides FAQs on the welfare exemption and the Veterans Organization exemption, but these questions and answers are more general in nature and not specific to the application process for SECs. While the current information on our website is helpful, we believe further review and revisions of the webpage are warranted in order to provide more information regarding the application process, as well as the filing requirements for both OCCs and SECs. Further, we plan to expand our current FAQs on our website regarding the welfare exemption and Veterans Organization exemption to provide more questions and answers specifically related to SECs. This part of the project will be tackled once we've completed our review, plan, and execution of the application claims and approval processes of the SEC project. And as we move forward with this project, we will continue to provide updates and information regarding our progress and improvements to allow for visibility into the process and to ensure that the board members are kept informed. Members, this concludes my presentation. I'm available to answer any questions.
All right, I see one hand, Antonio Vasquez.
Thank you, Madam Chair. And thank you, Ms. Keach. I'm glad that I know I raised it at the last meeting, and it sounds like you're obviously working real hard on trying to see what we can do in terms of that just to have those basic questions, basically the Q&A for a lot of these folks, and to try to make it as user friendly as possible. I guess my second piece would be, has the department kind of considered seeking public or user feedback on what needs to be improved or what is needed to make their experience in that whole navigation process a little bit easier?
Yes, that has been incorporated as part of this project. Our unit does communicate with taxpayers on a daily basis, so we receive suggestions and feedback that has contributed to areas of improvement that have been needed. So that those discussions have been helpful and have definitely been incorporated in this process.
Thank you. I appreciate it.
Thank you.
All right. Well, seeing that there are no other questions from colleagues, Ms. Taylor, let's go to public comment on these reports.
Certainly. AT&T moderator, please let us know if there is anyone on the line who would like to make a public comment regarding these matters.
Once again, ladies and gentlemen, if you would like to make a public comment on any of these matters, please press 1 then 0 at this time. Again, that's 1 then 0 on your phone. At this time, we have nobody queuing up for comment.
All right. Let's keep moving forward.
Thank you. The next item is K4A, Legislative Research and Statistic Division Chief's Report, Legislative Issues. Update on administrative and program-related legislative bills impacting the BOE. This item will be presented by Mr. Weatherby.
Mr. Weatherby, the floor is yours.
Thank you, Chair Cohen. So good afternoon, Chair Cohen, Vice Chair Schaefer, honorable members of the board. This is Dustin Weatherby, Chief of the Legislative Research and Statistics Division. So before getting to bills and the legislative update, I want to inform the board that the legislature has 2 new chairs of the tax committees. First, Senator Ana Capillero is the new chair of the Senate Governance and Finance Committee. She replaces Senator Mike McGuire, who is the new Senate Majority Leader. And then just yesterday, Assemblymember Jackie Irwin was named chair of the Assembly Revenue and Taxation Committee. She replaces Assemblymember Autumn Burke, who resigned at the end of January. So the legislature just had their bill introduction deadline this past Friday, February 18th, and in total, over 2,000 bills were introduced by the legislature. This means no new bills can be introduced by legislators, with the exception of constitutional amendments. However, legislators can still utilize gut and amends to effectively introduce new legislation and amend spot bills introduced before the deadline. The board's proposal to authorize a 5-year sunset extension to the Offer and Compromise program within the Alcoholic and Beverage and Tax program. We had conversations with the legislature in the list of priorities, and what we're looking at is a more efficient way to get this through by combining it with other agencies that are extending OIC sunset provisions. These OIC provisions have always been packaged and renewed together, and this would continue the best legislative practices. So I will keep the board updated on the status of this proposal moving forward. And then the board's proposal to provide deadline extensions related to the alcoholic beverage tax for situations related to the COVID-19 did not receive a legislative author this session. However, I'm working with legislative staff to carry the proposal next year. So attached to the PAN is a summary of the legislation affecting the Board of Equalization through just before the bill introduction deadline. Board members, as a courtesy note, I want to highlight that I will discuss some bills that were introduced Friday after the PAN attachment was posted. I will make sure to specify in my discussion that those bills do not appear on this month's PAN, but will appear on the March board meeting PAN attachment. The first bill for discussion is AB 1206 by Assemblymember Bennett, which will require that a rental unit continue to be treated as a lower income household when the income of those occupants increases up to 140% of the area's median income if the owner is a community land trust whose land is leased to low income households for the fiscal years 2022-23 through 2027-2028. This would allow community land trusts to continue to receive the welfare exemption for units where the occupants earn up to the 140% of the AMI, where current statutory law denies the exemption above 80% of the area's median income. The bill passed the Assembly on January 31st and is currently awaiting referral to a Senate committee. The next bill is Assembly Bill 1933 by Assemblymember Friedman, which would provide that a property is fully exempt from property taxation and is also within the welfare exemption if that property is owned and operated by a nonprofit corporation that is organized and operated for the specific and primary purpose of building and rehabilitating single or multifamily residential units if those units meet certain criteria, including but not limited to that are sold to first-time home buyers that are low income or moderate income. It requires those units to be made at an affordable cost to buyers. So this bill is awaiting referral to committee and may not be heard in a committee until March 13th. The next bill I want to highlight is not listed on the PAN attachment. So AB 2651 by Assemblymember Petrie Norris extends the sunset date for the welfare exemption for community and land trusts that acquire property for development or rehabilitation for housing on or after January 1st, 2020. The current sunset date for these provisions is January 1st, 2025, and this bill would further extend that sunset date until January 1st, 2030. The next bill that list is also not listed on the PAN. This is Senate Bill 1456 by Senator Stern, which eliminates the total welfare exemption amount allowed to a taxpayer during a fiscal year in relation to low-income housing. This bill would remove the cap of $20 million of assessed value. So this bill is also awaiting pending a referral to a committee and can't be heard till next month either. And then Senate Bill 862 by Senator Umberg expands the spaceflight property tax exemption to include property used for spaceflight activities, and it definitely extends the sunset date beyond the January 1st, 2024 lien date. This bill is currently in the Senate Governance and Finance Committee and is awaiting hearing. And the final bill, board members, I want to highlight is Senate Bill 1073 by Senator Grove, which would provide a partial disabled veterans exemption to a veteran that is partially disabled beginning with the January 1st, 2023 lien date. So this bill is currently awaiting referral to committee and it can be heard during committee hearings beginning in March. And then as an additional note, board members, there are multiple proposed propositions that are currently in circulation. To ensure you are informed, I have included in my weekly reports information regarding propositions which may affect our programs or the agency. If you have any questions on these initiatives, I'm available to set up a meeting with you in your offices to provide more information as needed. So this will conclude my presentation on this item, and I'm available to answer any questions.
Thank you for the presentation, Mr. Vasquez.
Yes, thank you. And thank you, Mr. Weatherby. I think you touched a little bit on what I wanted to say, but just wanted to add to that. You know, I guess my question really relates to the 31 new affordable housing bills that went into effect January 1. You kind of hit on a few of them already. Of course, you know, as you know, the Governor Newsom signed these bills as part of his whole California comeback plan and $22 billion investment in housing and homelessness. The goal is to create over 84,000 new housing units, including 44,000 for homeless. I guess my question to you is it a possibility maybe at the next board meeting to kind of go through those 31 and give us maybe a little brief synopsis of those as they possibly could affect our district assessors in our respective areas, or the AABs for public agencies and their constituents, if that's a possibility. I think that would be really helpful.
Thank you, Board Member Vasquez. I would be happy to look into, I believe you're referring to the early budget action items that were taken by the legislature and the governor. Yes. I have gone through those bills. A lot of the programs that were affected did not touch the BOE, but I would be happy to kind of circle back and double check and then follow up with your office if that's acceptable.
I appreciate it.
Any other questions for Mr. Weathersby? Mr. Weathersby, how did you kind of gather this information? What is your style of of keeping, I guess, your finger on the pulse?
So luckily the state uses legislative tracking system, so I'm able to use key terms around the BOE and any of its related programs and items. And so I get daily updates on legislation that affects any of those items, and then I'll individually review the bills to see if they still applicably apply to the BOE's programs or whether one of them is just included in a legislative definition. And so for bills that don't get picked up by those, I still go through all the bill introductions and amendments to see if it touches the agency or any of its programs in a more tangential way.
Okay. What's the feel? I mean, in the Capitol, are people coming back and working the halls and having lunch, and are still people still working from home and remote calling in?
So the legislature has moved out from the annex into the new swing space over off of O Street. From my understanding from talking with legislative staff is a lot of staff are still working remotely, and a lot of the committee hearings, while they're in person, a lot of third house advocates and other state agencies are still utilizing teleconferencing to access the legislatures through those committees. So it's kind of it's a mixed bag, but mostly it's leaning towards still teleconferencing and remote meetings.
Okay, thank you. I appreciate that. Mr. Vasquez has a question. Mr. Vasquez?
Yes. Thank you. I forgot I was going to make a comment also, and maybe a possible suggestion, and see what the members how they feel about this. And it actually leads into kind of a question that I like and concern to share with staff as well as our ED and the members related to legislation. I would like to know the status of the board's proposed amendments to clarify the statutes extending deadlines in the emergency section 155 and section 15620. Last I recall, we were to have a public discussion at our January meeting. So members, I would propose we make sure it is placed on our March meeting for discussion, possible action, if the board is on board with that. And pretty much the board, the BOE staff devoted substantial time and work over the last 6 months preparing an issue paper, submitting proposals of draft language, holding an interest parties meeting, and issuing documents addressing numerous concerns. We owe it to the public and the BOE staff, I think, and ourselves as constitutional officers to discuss the proposals as currently worded and determine if the changes should be made and what actions should be taken if that's of any concern of the members and staff. I was kind of hoping to see if we could at least continue that discussion. I know it's not an agenda item today, but I was wondering if we could make sure that happens in our March meeting, if possible. Thank you.
Thank you. Let's go to public comment.
AT&T moderator, please let us know if there is anyone on the line who would like to make a public comment.
Once again, if you'd like to make a public comment, please press 1 then 0 at this time. At this time, nobody's queued up.
All right, thank you very much. Seeing that there's no public comment, there's no further discussion, let's call the next item.
The next item is K5A, Taxpayer Rights Advocate Office Report, Taxpayer Rights Advocates Annual Report, presentation of the 2021 TRA Annual Report highlighting the office's accomplishments, involvement in projects, and examples of cases illustrating services provided. This matter will be presented by Ms. Thompson.
Ms. Thompson, all right, now it's our favorite time of the agenda where we get to talk about how you broke down the report on taxpayer cases and the valuation category differing from the administrative category. Thank you again. In particular, I enjoyed seeing the data and how the specific cases inquires broke down among the various subcategories. I know that took a lot of work, but I just want to publicly affirm and express my appreciation so you and your staff know how grateful I am. So with that, I'd like to open up the floor to you and your presentation. Thank you.
Thank you so much for those kind words. It was a lot of work, and I do have my staff to thank for it, which I am internally grateful. So I'll go ahead and proceed. Good afternoon, Chair Cohen and honorable board members. I am Lisa Thompson, Chief of the Taxpayer Rights Advocate for the Board of Equalization. I'm pleased to present to you the 2020-21 Taxpayer Rights Advocate Annual Report for property taxes and the alcoholic beverage tax. As part of my presentation, I will describe the contents of the report, then provide an operational update as to the status of projects and activities of the TRA office to keep you informed. The TRA annual report is issued in accordance with the Morgan Property Taxpayer Bill of Rights under the provisions of Revenue and Taxation Code Section 5904. And the report highlights the Taxpayers' Rights Advocates Office's accomplishments, examples of cases illustrating the services our office provides to taxpayers, issues that our office works on to resolve, and describes our office's involvement in educational projects to help taxpayers. In this year's annual report, we have expanded reporting significantly. This year's report includes several pie charts identifying percentages for various reporting metrics, the percentages of completed cases for each of the 4 equalization districts, the percentages of completed cases for valuation category versus the administrative category, as well as topics within each of those 2 categories. We provide those in topic areas. So for fiscal year 2021, our office completed work on 232 cases. All were in the area of property taxes. Of the completed cases, 18% were from taxpayers in District 1, Board Member Gaines's district, 36% from District 2, Board Member Cohen's district, 23% from District 3, Board Member Vasquez's district, and 23% from District 4, Board Member Schaefer's district. And 72% of the cases were in the valuation category, which pertains to topics such as decline in value, change in ownership, new construction, exclusions from reassessment, exemptions, assessment appeals, and general property taxation. 28% of those cases were in the administrative category, which includes topics such as creating and mailing of tax bills, refunds, and penalties. As to the topic area within the valuation category, the report provides a breakdown into 8 topic areas. The largest percentage of those cases involved exclusions from reassessment at 37%, followed by change in ownership at 23%, with exemptions at 10%. As to the topic area within the administrative category, the report provides a breakdown into 6 area topics. The largest percentage of cases involve special assessments at 32%, followed by late payment penalty cancellations at 25%, with the next highest percentage for delinquent or defaulted taxes at 18%. In addition to contacts from taxpayers that our office sets up as a case that we work on, our office also receives contacts from taxpayers that are seeking assistance in areas that our agency is not involved in. In those cases, the TRA office assists those taxpayers by directing them to the appropriate state or county agency. That number varies on a monthly basis, but in total for fiscal year 2021, there were 80 taxpayers or requesters that we directed elsewhere. The annual report also describes how the public becomes aware of the services offered by our agency's TRA office, so taxpayers know that we're here to help them. Our agency's publications provide the TRA office's contact information, as does CDTFA's publication 145, California Taxpayer Advocates, which identifies contact information for the advocate office of our agency, as well as for other state agencies and the IRS advocate. County assessors' offices also refer taxpayers to our offices, as do the board member offices. They direct taxpayers to our offices or forward information to our offices asking us to assist taxpayers who reached out to your offices. Our agency's website is also a resource for taxpayers where taxpayers can become aware of the TRA office. At the bottom of every page of our agency's website, there is a link to the Taxpayer Rights Advocate Office. Other state agency Agency representatives also refer taxpayers to our office, such as the Franchise Tax Board or the California Department of Tax and Fee Administration. Additionally, our communications officer and department issues social media posts to taxpayers so they're aware of our offices. So taxpayers can contact us in several ways. They can contact us using a web intake form from our website where they can input the information in a form and it sends us an automatic email. They can also contact us by phone. The website intake form is good for taxpayers in that it allows them to identify their property and the nature of the concern in which they need our help. So the two primary functions of the TRA office are to ensure fair and equitable treatment of taxpayers in the assessment and collection of property taxes, and to recommend changes to policies, procedures, and laws to improve and ease taxpayer compliance. This annual report contains examples of cases that our office worked on to illustrate how the taxpayer's problems are resolved. And our role generally involves review and explanations of processes and laws, contact with local county assessors or tax collectors' offices to help resolve the problem or concern that the taxpayer has with the local department. Oftentimes, a taxpayer just needs assistance in understanding what documentation is needed to be provided to a county assessor's office to arrive at a solution they need, or to receive confirmation that they were treated fairly according to the law. There are several examples included in this year's annual report illustrating the types of cases that we received and how we assisted taxpayers. In this year's annual report, we highlighted one case concerning defaulted property taxes, one case addressing the parent-child exclusion, and two cases addressing the base year value transfer for seniors, and then one case for the disabled veterans exemption. One case that I would like to highlight is the disabled veterans exemption. In this case, a taxpayer whose husband recently passed away had contacted our office seeking assistance with the application for the disabled veterans exemption that was filed with an assessor's office. The widow was concerned about losing her home because she couldn't afford to pay the property taxes. A few years before her husband's death, the Veterans Administration had determined her husband's disability rating at 100% and service related, but they weren't aware that the disabled veterans exemption from property taxes was available, so they hadn't applied for it while her husband was alive. The Taxpayer Rights Advocate Office assisted the taxpayer in understanding the qualifications for the disabled veterans exemption and documentation needed to submit to the assessor's office to show qualification retroactively to the effective date of the disability, limited to 8 years back. We coordinated with the assessor's office to have the claim expedited, and the exemption was granted with several years of property tax refunds issued by the tax collector's office. Many cases that our office worked on in fiscal year 2020 involved exclusions from reassessment, specifically in the area of base year value transfers for seniors, as well as transfers between parents and children. This annual report highlighted an example for a transfer between a parent and a child where a taxpayer had inherited a rental property from her mother, and the taxpayer was concerned that she wouldn't qualify for exclusion as a result of the passage of Proposition 19. We helped the taxpayer understand that the mother had passed away prior to the February 2021 effective date for intergenerational transfer provisions of Proposition 19. So she did qualify for exclusion under the prior law. For purposes of change in ownership, for property tax purposes, the date of death is considered the change in ownership date, not the actual date of property tax distribution. Once the taxpayer completed the proper claim forms, the reassessment was reversed and the lower value that her mother had on the property was reinstated. With respect to base year value transfers for seniors, we highlighted two examples. One which addressed the base year value transfer to request to a different county, and another request for the base year value transfer to a replacement home of higher value. Because statutory changes were made to the base year value transfer and intergenerational exclusions resulting from Proposition 19, a constitutional amendment approved by the voters in November 2020, our TRA annual report pointed out the impact of the amendment and integrated it into the cases we worked on during the year. With respect to base year value transfers, we identified changes due to Proposition 19 to provide greater flexibility as to where a senior can purchase a replacement residence now anywhere in the state. As a result, as opposed to only 10 counties that had adopted an ordinance accepting such transfers from other counties previously. Additionally, a senior can now buy a replacement home with a higher market value than that original home, with the difference in market value being added to the transferred value. One case I would like to highlight from the 2021 TRA annual report concerns base year value transfer request for a taxpayer that sold his home and purchased a replacement home of higher value. The taxpayer had sold his original home in January of 2021 and purchased the replacement in March of 2021. So unfortunately, it did not qualify. The TRA office helped the taxpayer understand that although Proposition 19 was approved by the California voters in November of 2020, the base year value transfer provisions were not effective until April 1st, 2021. Our office explained that that was specified in the constitutional amendment, but that the taxpayer could still take advantage of the base year value transfer provisions of Proposition 19 if he bought a different home as a replacement property, as long as it was within 2 years of the original property that had sold in January 2021, with that replacement, of course, being purchased after the April 1, 2021 effective date. This annual report also identifies issues that the Taxpayer Rights Advocate Office was involved in resolving. As a result of specific contacts from taxpayers and issues raised at the annual Taxpayer Bill of Rights hearing, our agency becomes aware of issues that are out there. This year's annual report for 2021 identifies 2 projects: the Assessment Appeals Process Project and the Solar Energy New Construction Exclusion Project. With respect to the Assessment Appeals Project, as a result of comments made at a Taxpayer Bill of Rights hearing by a taxpayer group regarding the use of data on assessment appeals process, our agency's property tax department began a project to facilitate resolution of the issues. Work began on the project in fiscal year 2017-18 and concluded in fiscal year 2021, the year of this year's annual report. The project resulted in changes to 5 property tax rules pertaining to appeals hearings, adoption of a form for county assessors to use when requesting information from a taxpayer under Revenue and Taxation Code Section 441D, and revisions to language in our agency's assessment appeals manual. The second project that is identified in the annual report is the Solar Energy New Construction Exclusion Project, which was initiated by our agency's property tax department in part due to contacts made to the Taxpayer Rights Advocate by a taxpayer representative. The project was initiated to address issues that emerged since the release of our agency's guidelines for active solar energy systems new construction exclusion. And as part of that project, a proposed new property tax reporting form for solar energy power plant equipment to county assessors' offices was drafted and distributed as part of one phase to that project. We anticipate work will continue on this project after the work associated with the implementation efforts of Proposition 19 has been completed. Next, the Taxpayer Rights Advocate Annual Report contains a section on taxpayer service improvements. This section has 4 parts. 1, educating the public. 2, educating the public about Proposition 19. 3, ease of access to information. And 4, forms review. The portion on educating the public discusses the TRA office's role in taxpayer education through publication of its information sheets. It explains that in 2018, our office and the California Assessors Association discussed providing education through the issuance of short information sheets for various exemptions and exclusion topics written in simple, non-technical terms. Discussion in the annual report identifies completion of 4 information sheets from July 2018 to June 2020, addressing exclusions from transfers between parents and children, transfers from grandparents to grandchildren, and base year value transfers for persons age 55 or over, and for disabled persons. It further indicates that as a result of the passage of Proposition 19, our office suspended work on information sheets until implementing legislation for Proposition 19 was passed by the legislature and after our agency issued guidance for that implementing legislation. The Taxpayer Rights Advocate Office is committed to making improvements to taxpayer education and providing taxpayers with information in simple, understandable terms. Our office values the importance of having these information sheets available as a resource to taxpayers where they can read about the main requirements, helpful hints, and where to find additional information. I will be discussing information sheets more and recent work with the California Assessors Association in this regard in the second part of my presentation for the board members as part of the update for Part B of Agenda Item K5. The second part of the taxpayer service improvement section is on educating the public about Proposition 19. It addresses publication of the Proposition 19 fact sheet in collaboration with our agency's communications officer as part of the agency's Proposition 19 implementation and action plan for education and outreach. Our property tax department issued various guidance addressing many aspects of Proposition 19. We felt it was important to publish some simple, straightforward information concerning Proposition 19 designed specifically for taxpayers. The fact sheet was issued to provide information on the requirements, benefits, and situational examples of how Proposition 19 works. The Proposition 19 fact sheet, published on February 1st, 2021, provided information on the parent-child and grandparent-child exclusion that became effective February 16, 2021, and provided information on the base year value transfer provisions for seniors, disabled persons, and victims of wildfires or natural disasters that became effective April 1st, 2021. Of the end of fiscal year 2021, the year of this report, implementing legislation for Proposition 19 had not yet been passed, so the annual report identified that our office would update the Proposition 19 fact sheet after implementing legislation and corresponding guidance was issued by our agency. Discussion on the TRA's work on the upcoming Proposition 19 fact sheet will be included as part of the next year's annual report. The third part of the taxpayer service improvement area is on ease of access to information. And this area discusses the TRA office's commitment to ensuring the public has access to information when they need it. We do this through examining our agency's website with the taxpayer in mind, and we coordinate with our agency's property tax department and communications officer to update information on the website to ensure sufficient information is available on various topics and that it can be easily accessed. The 2021 TRA annual report indicates that our office reviewed the material issued by our agency pertaining to Proposition 19 during fiscal year 2021, and that we believe the information disseminated was comprehensive and responsive to the needs of taxpayers and assessors. During the time period of the TRA's annual report, our agency issued 8 letters to assessors concerning Proposition 19. Our office believes that our agency was proactive and timely in posting information concerning Proposition 19, and that the property tax department and the legal department did an excellent job. The fourth part of the taxpayer service section is for forms review. This area discusses the TRA office's role in periodically reviewing property statements and other forms prescribed by our agency to determine if the forms or its instructions discourage or promote taxpayer compliance. This is done as part of our responsibilities under the Morgan Property Taxpayer Bill of Rights, specifically Section 5906 of the Revenue and Taxation Code. As a result of working with taxpayers, the TRA office becomes aware of changes that are needed to a form, either the form itself or to the instructions. The 2021 report identifies a recommended change to a form that a taxpayer can use to apply for a base year value transfer from a property that was acquired by a public entity, Form BOE 268. A change was made to the form to clarify a claim could be filed more than 4 years after their property was taken by eminent domain and that retroactive relief was available due to a statutory change. The form revision will ensure that taxpayers who were unfortunate enough to have their property acquired from a public entity may submit a form to the county assessor's office requesting a base year value transfer, even if they weren't able to submit that within 4 years of the acquisition by the public entity. Excuse me. The last part of the annual report are the appendices. And Appendix 1 contains the property taxpayer bill of rights provisions, which pertain to property taxes. Appendix 2 contains the California taxpayer bill of rights provisions specific to the alcoholic beverage tax. In connection with the alcoholic beverage tax provisions, at a past board meeting, Vice Chair Schaefer had asked about the dollar amounts in the statutory provisions on the tax liability compromise and the dollar amount, and if that dollar amount had ever changed. I indicated that I would circle back and answer that at a later date. I would like to take this opportunity to respond to that now. The code sections that Member Schaefer was referring to was Revenue and Taxation Code Section 32471.5 and Section 32572, which are in the Appendix 2 of the annual report. The amount in Section 32431.5 has remained unchanged since it became law in 2006. And amount for the alcoholic beverage tax is consistent with the Bill of Rights provisions for the different types of business taxes that are administered by the California Department of Tax and Fee Administration. The amount in Section 32572 increased from $1,500 to $2,300 in 2015 as a result of Assembly Bill 1277, which is from Chapter 789 Stats of 2015. As to Revenue and Taxation Code Section 32471.5, that addresses the Executive Director and Chief Counsel's ability to compromise a final tax liability of $7,500 or less for liabilities generated by a business that has discontinued or transferred, and the authority to compromise a tax liability greater than $7,500 but below $10,000 with the approval of the board. Revenue and Taxation Code Section 32472 addresses the ability to order a release of liability or notice to withhold up to $2,300 upon the finding that it threatens the health or welfare of the taxpayer, his or her spouse, and dependents or family. At last month's board meeting, as part of the Legislative Research and Statistics Division report made by Chief Dustin Weatherby, he discussed a legislative proposal to increase the minimum threshold for the Executive Director and Chief Counsel that they can compromise from $7,500 to $10,000 in Revenue and Taxation Code Section 32471.5. So next, as far as this, so basically the annual report, and if you need further information, Vice Chair Schaefer, I'm happy to provide that. But this TRA annual report is posted to our website and can be accessed under the Taxpayer Rights Advocate area. In accordance with the Morgan Property Taxpayer Bill of Rights statutory provision, this annual report provides a basis for the upcoming Taxpayer Bill of Rights hearing. In relevant part, Revenue and Taxation Code Section 5906D states that the board shall conduct a public hearing soliciting input from assessors, other local agency representatives, and taxpayers to address the advocate's annual report and to identify a means to correct any problems identified in that report. With respect to the alcoholic beverage tax, Section 32463 provides that the board shall conduct an annual hearing where industry representatives and individual taxpayers may present their proposals on changes to the alcoholic beverage tax, which may further improve voluntary compliance and the relationship between taxpayers and government. Both of these provisions are identified in the appendixes of the annual report. The TRA Bill of Rights hearing will be noticed with ample time for assessors and tax collectors statewide to display posters and flyers in their office for taxpayers to see. And I will be collaborating with our communications department to publicize the hearing for taxpayers. Last year, we created a video about the hearing, which was posted to our agency's website. So we will explore creating another video. Additionally, I reached out to numerous taxpayer organizations so they could notify their members and taxpayers about the hearing. I will also, Executive Director Fleming had touched on this earlier, but that we will be having an advisory council meeting on next week. And I will also be reaching out to those members and asking them to kind of spread the word to other people as well. And generally, the hearing is held in August of each year. And the TRA office will confirm this date, the specific date and time of the hearing with our agency's executive director and the board chair. However, historically, it has been the first day of the August board meeting. Letters to assessors will also be distributed advising of that. It is important to keep in mind that the TRA office works with taxpayers on their issues throughout the year. So many of the issues have been resolved during that year and taxpayers choose not to speak at the hearing. We, of course, enjoy hearing from taxpayers that our office worked with in the past to assist them with their problem. At the hearing, taxpayers, industry representatives, and other parties can comment on any areas in the annual report, items that our office may be working with them currently on, or on any other areas of concern regarding property taxes or other programs that our agency administers. Before moving on to part B of my agenda item for the update on the status of pending and upcoming projects and activities, I would like to take this opportunity to thank my staff in the TRA office for all of their hard work in helping taxpayers throughout the year. They play an integral role in the activities presented in the annual report, and I'm very proud of them and truly appreciate all of their hard work. This concludes my presentation for the TRA office annual report, and I'm available to answer any questions at this time, or I can address them after my brief update on the project and activities of the TRA office.
Thank you. I have a question. I see that also that your office published a series of short information sheets on topics as transfers of property between parent and children and grandparent and grandchild, parents over, adults over, persons over 55 of age, and on replacement property. Do you have any recommendations for additional taxpayer education or outreach to assist taxpayers in understanding the exclusion from reassessment and change of ownership issues?
So, so my next part will kind of touch on that, and so we're focused on at least the certain information topics, as I'll talk about on the next portion. We have worked with the California Assessors Association to identify topics, but our focus is exemptions and exclusions, and so exclusions and exemptions. So that's focused on the taxpayer, being able to be aware of and take advantage of property tax savings that may be available to them. So that is kind of what we're focused on doing. And so the information sheet availability, having access to that is key, I think, to being able to decipher all of the information into a very short and concise information. So that's where we're focused.
Okay, so the answer is yes.
Well, yes, I mean, yes.
You will be doing more outreach?
Yes, we are focused on like those exclusions. So the base or value transfers are exclusions, exactly. Same with the parent-child and grandparent-child, as you said.
I
Yes.
mean, that seems to make sense. That's where the majority lion's share of your questions are coming from, rightfully so, right? We're talking about a lot of money that people and families tie into their property taxes. So going forward, should there be a publicity campaign to greater inform the public about the services available through your office?
So yes,
my questions are really statements of asking you for your statement of opinion. You're the taxpayer advocate. You're forward facing, right? You are kind of like almost like the first line, the first point of contact that the public has when they're dealing with the Board of Equalization.
So yes, if the taxpayer is having a problem that they're hoping to resolve, then yes, we are there, definitely the first point of contact. So yes, I am working with the communications officer, Peter Kim, to do this. So we're kind of coordinating to discuss how best to do that. Social media post, and we'll keep you informed, I guess, of future ones. But yes, we have been coordinating on this, how to go ahead and do this. And really a good time will be right after we issue we want to advise about the issuance of the Proposition 19 fact sheet once that's that's actually issued, as well as these information sheets. And we, as you'll see, that's my next portion of it, we will be drafting these.
Okay, so that leads me to another question. Should there be a program or some kind of a program issuing press releases around property tax deadlines? Do you think there's a need for that? Or are property owners they know April and December? Or
yeah, I mean, I know that there are there's different mechanisms where the property tax department notices on different property tax deadlines. We could look and see and circle back with you on an actual press release. I think there are for certain deadlines, but I'm happy to look into that and coordinate with the appropriate section on that.
Again, I was just looking for your professional opinion.
I think it would be helpful, yes.
Okay, just a couple more questions, and this relates to the nature of your work in relationship to the different county assessor's office. Is there a certain level of coordination of information? Does your office reach out to county assessors to inform them that your office is available to offer independent recommendations regarding property tax issues?
So, I mean, assessors are aware of our office. I mean, in that we notify them every year of the, Taxpayer Bill of Rights hearing. That letter, goes directly to assessors. We have a specific letter to them, not just a letter to assessor. We notify them, mail them posters and flyers. Of course, I attend the different California Assessors Association meetings, and we discuss the, kind of the role of the TRA office, and that. And so what we will be doing is, with the issuance of the information sheets that we will be doing for Proposition 19 is, I've already been in communication with the current president of the CAA, Leslie Morgan, and and she'll push out notifications as we issue these information sheets. And so individual assessors then may add links to their websites to our fact sheet, and then know they're available, and then can inform their staffs and kind of let everybody know there are additional resources for taxpayers at that time.
I appreciate that. Now I'm done with my questions, and I'm going to go to Mr. Vasquez.
You pretty much asked most of my questions. The only thing I would add, and I would just kind of echo what you're saying, just in terms of the outreach piece, which I think you did an excellent job with in a thorough presentations on this annual report, and I think you mentioned it on page 10, the outreach efforts you've done. And I was just going to kind of piggyback on what Madam Chair just talked about in terms of how do we get it out to more folks, right? And if anything, what possible hearings that we could do to just try to disseminate as much of this information as possible, because I think you're doing some great work, especially for those I know that we've sent your way. You've done an excellent job in troubleshooting their problems, but I think you're like the best kept secret for a lot of these taxpayers, and we just need to figure out a better way to get the message out that the TRA office is available to them.
Well, thank you. Yeah, so I will, again, coordinate with the communications department on how to do that. And, we certainly appreciate, your member offices referring taxpayers, and that might be a way to do that, to include, just some contact information on the TRA office. And I'm happy to provide some standard, points that you might want to include in your newsletters or emails to your constituents, and you can, you choose to use them or revise them, and that might be very, very useful to taxpayers in California. So I would appreciate that.
Thank you.
Do you want me to go ahead and go on my next?
Yes, I would love for you to do that.
Okay.
Because there's no other question. Oh, wait, I'm sorry. Senator
Okay.
Gaines has a question. Senator, you have to unmute yourself. Yeah.
Thank you for your presentation, Ms. Thompson. I appreciate it. And we've tried to highlight it on our website in terms of the availability of the taxpayer rights advocate and how important that is. And I think we still need to figure out, as has been raised by other members, how do we get the message out to folks that they have this option available to them? And so I know that in our discussions yesterday, I'd spoken to Peter Kim about seeing if we might be able to bring the taxpayer rights advocate. How do we highlight it on our general website so that people are aware that this is a service that they have available? And so I think we need to continue to focus on that, because there's actually another step available for taxpayers. Initially you would ask your questions of your assessor. The Assessment Appeals Board is another step, but there's also the taxpayer rights advocate. And I've found that it's been helpful for my constituents. You've highlighted a lot of problems and questions that you've been able to answer for our constituents. So as Member Vasquez had mentioned, how do we expand upon this best kept secret? So if you just continue working with the communications department, with Mr. Kim, I don't think we can highlight it enough, quite frankly. It's a great interface. I mean, we have the ability as members, as elected members, to speak to our constituents, and they come to us with issues. But this is another opportunity for outreach. Thank you.
All right. Thank you. Ms. Thompson?
I think, does Mr. Schaefer have a...
Oh, I don't know. I didn't see his hand. Mr. Schaefer, do you want to speak? Mr. Schaefer, do you want to comment on Ms. Thompson? No? Okay, no problem.
Okay,
no.
thank you.
Yeah.
Okay, yeah, I wasn't sure. So yes, I'll continue on with my part B then. Thank you. Members, at this time, I would like to provide you with the status of pending and upcoming projects and activities to keep you informed. As to the number of completed cases by the Taxpayer Rights Advocate Office last month, in January 2022, we completed work on 18 cases, 13 in the evaluation category and 5 in the administrative category. The majority of valuation category cases address exclusions from reassessments, exemptions, and change in ownership. And I'm not going to go through the specific detail as I have in the past, because I presented the annual report, but next month you'll hear from me as to my regular update. As to projects, at last month's board meeting, I updated the members on progress that was made regarding taxpayer education and the consensus on the top 5 topics in need of taxpayer education. And I explained that in 2022, our plan was part of our plan of taxpayer education was to provide information sheets and to work in collaboration with the California Assessors Association to identify the top 5 topics or issues in need of taxpayer education, then developing material addressing those areas. I indicated that the TRA office coordinated with the California Assessors Association to solicit input from assessors on what they thought were among the top topics that could benefit from taxpayer education, and identified what we felt were the top 5 topics. talked with the CAA president, the Honorable Leslie Morgan, Shasta County Assessor, and she was in agreement that the topics our office identified were among the most pressing issues where taxpayer education was needed. From the TRA office perspective, our thoughts on needed education were as follows. 1, intergenerational transfers under Proposition 19 between parents and children. Intergenerational transfers under Proposition 19 between grandparents and grandchildren. Base year value transfers under Proposition 19, persons age 55 and over. Base year value transfers under Proposition 19, disabled persons. And property tax welfare exemption for nonprofit organizations. We also identified one more, which was change in ownership reporting requirements when a real property owner dies. Now that the topics have been agreed on with the California Assessors Association and letters to assessors have been issued on the implementing legislation for Proposition 19 with the passage of Senate Bill 539 as to base year value transfers, and the soon expected issued LTA on intergenerational transfers, the TRA office can begin drafting information sheets on 4 of those topics. The Taxpayer Rights Advocate Office is committed to making improvements to taxpayer education and providing taxpayers with information in simple and understandable terms. Our office values the importance of having information sheets available as a resource to taxpayers, where they can find information about various exclusion or exemption topics that can benefit them. Not only do the information sheets provide a resource for taxpayers visiting our website, but they also provide a resource where county assessors can and their staff can refer taxpayers in their counties to it. As information sheets are published in 2022, we will coordinate with the CAA president, Leslie Morgan, so she can notify assessors of the availability of the material that they can share with taxpayers in this county. In their county, and at future board meetings, I will also provide you with further updates to keep you informed. This includes my update on the activities of the TRA office, and I'm available to answer any questions.
I have a quick question, if I may. Senator Gaines, forgive me for just interjecting here. This is directed towards Ms. Fleming. Ms. Fleming, can you hear me?
Yes, ma'am, I'm here.
I'm listening, and I'm reminded that in the last meeting we requested a poll, that you take a poll of the board members about other options to include the listing of topics.
Yes, ma'am.
Did this happen? Did I miss it?
Thank you for the question. No, you didn't miss it, ma'am. Thank you for the question. We've added that to Ms. Thompson's list of priority things to look at. She was trying to finish up honestly, members, and we appreciate your patience as she's trying to focus on finishing up that annual report, but it is on the list, and so we will lend some assistance to try to get that survey completed. Get your input.
All right, thank you, thank you.
And so,
all right,
if I may, just a moment on mic, Mr. Kim will ask for your assistance in helping to get that information.
Okay. Mr. Gaines has a question for Ms. Thompson.
Yeah, thanks, Chair Cohen. I'm just curious, looking at the website here, for Taxpayer Rights Advocate, there's a button kind of on the bottom of the page, and I'm just wondering if we could just take a look at it and see if there's other options in terms of highlighting it. It could be in a different color, or it could be higher up on the page. But I'm just wondering if that could be examined in terms of priority on our website.
Yeah, so I'm happy to talk with the communications officer on that. I mean, there's several ways to do that, but I'll talk with him to see how we could kind of highlight that a little more, maybe another area also in addition to it, certainly.
Okay, that's great. Thank you.
All right. Seeing no other questions, let's keep going.
All right. May we call for public comment?
Yes, please. Yes.
AT&T moderator, please let us know if there is anyone on the line who would like to make a public comment regarding our Taxpayer Rights Advocate report.
Ladies and gentlemen, if you would like to make a public comment, please press 1 then 0 at this time. Currently, there's nobody else in public, nobody in public comment.
Thank you. Ms. Taylor?
Yes. The next item is L1A, Assembly Bill 1206, Housing Justice Tax Equity Act, for discussion and possible action related to the Board of Equalization officially supporting Assembly Bill 1206, which raises the property tax exemption threshold for community land trust properties to match the federal requirement of 140% average median income. This matter will be presented by Chair Cohen and Mr. Vasquez.
All right, let me get to my notes. So, colleagues, Board Member Vasquez and I have placed this item on the agenda to request that we as a board support Assembly Bill 1206, the Housing Justice Tax Equity Act, authored by Assembly Member Steve Bennett. California is facing an affordable housing crisis that undermines the Californian dream and threatens the state's long-term progress and prosperity. And when faced with this crisis, innovative solutions are required. So community land trusts have become a valuable tool to ensure the availability of permanent affordable housing that relieves part of the significant financial burden that lower income households face for rent costs they often cannot afford. So specifically, this bill would do a couple of things. It would allow community land trust properties that already have a property tax welfare exemption to keep their exemption if a resident's income rises above 140% of the area median income. The welfare tax exemption helps keep rents affordable for low income and moderate income residents in community land trusts, but also for the current tenant and future tenants who occupy the unit. AB 1206 ensures that a community land trust will avoid a sudden and unexpected increase in their tax bill by increasing the income threshold on par with the federal requirements. Similar flexible provisions have become law with the passage of Assembly Bill 1193. 1193 was enacted in 2017. It provided for the same welfare exemption threshold increase, 80% AMI to 140 for low-income housing tax credit developments. But AB 1260 would just take a similar action by extending income flexible provisions like those authorized for low income housing tax credit to be specified for the community land trust. So I'd like to point out that AB 1206 has passed out of the Assembly chamber by a 75-01 vote with bipartisan support and is currently in the Senate. At this time, I will defer to my esteemed colleague, Mr. Vasquez, who I believe has a few remarks he'd like to share. Mr. Vasquez.
No, thank you. I think you laid it out pretty well in terms of what it means and what we need to do. I would just like to encourage all members to support this legislation in the interest of protecting critically needed affordable housing. And if I'm assuming we're going to try to put together a letter as a body, but I think it would be probably powerful also if maybe each individual member also submitted a letter in support as well from your respective districts.
Okay. All right. Well, I see a hand, Mr. Vasquez. Did you complete your thought?
Yes.
Okay. Then let's go ahead and hear from Ms. Dowers.
Thank you. I think it's a great bill, and I think it's definitely something that the Board of Equalization members should support. I just want to be consistent. Last year, when there was legislation that the board supported, I asked for the letter to be drafted or come from the chair on the behalf of the members. And I'm not sure if you are open to having that same process this year, for this particular support letter would come from the Chair Cohen.
to me, it doesn't, whatever you think is the most powerful, I think whatever, we send a strong, I was kind of suggesting that I think we should do that, and possibly I think each member should also send one as well, just to show that, within our respective districts, we really need to make sure this thing goes forward.
Right. I think it's when it comes from an elected official, it has more weight. So I think basically have it coming from the chair's office would be great. But I stand in support for it.
Thank you. Okay. All right. So let's hear from Ms. Fleming, her thoughts on this legislation.
Well, thank you, members. I appreciate the opportunity. I agree that this is a good opportunity for the board to show some support to a really important matter in California in terms of affordable housing. I'm going to invite my staff to join me in this conversation today. So if Mr. Young and Mr. Weatherby would join me on camera. Dave has some really good history in terms of some of the detail as it relates to this matter. And I'd like for Mr. Young, if he would, to offer some of those recommendations. And then if there's any other Q&A after Dave's comments, Mr. Weatherby can also join in the conversation in terms of legislative process. So members, if you will, we'll defer to Mr. Young to give you a little bit more detail of his experience in this area. Mr. Young.
Of course, thank you, Ms. Fleming, for the opportunity to address the board. I think this bill will go a long way in providing some equity to CLTs. As you already mentioned, this 140% limit is already given in general to other developers of low-income housing that use tax credits, and the CLTs may or may not use such tax credits. So extending this to CLTs, so when their residences do go beyond the 80%, I think that will go a long way in preserving the welfare exemption for this type of housing. So I think in general, it aligns well with the governor's desire to increase the affordable housing stock and maintain it so in California. And the board's expressed interest in doing so too.
All right, thank you. Colleagues, any other questions for staff? All right, let's pivot in.
If I could.
Sure, Senator Gaines.
Yeah, if I could, just a question of Mr. Young.
Yes.
In terms of, can you give me an idea in terms of the impact of raising this threshold to 140%? I mean, do we have anything that clarifies how many additional housing units might be available for folks as a result of the passage of this bill? Have they done any sort of analysis?
I'm not aware of any analysis that they've completed on this. And if I could just add just a tiny bit of clarity to this proposal, what it actually proposes is that if a tenant moves in and initially qualifies under the 80%, when they eventually, the goal of affordable housing is to lift somebody out of poverty. And if they are able to basically raise their income up to 140%, there's already federal statute that says if you qualify before and you live in one of these low-income housing units, that they cannot basically ask you to leave until you break 140%. So it may not necessarily increase it, but it will preserve the ability for the developer to keep those units rated as affordable housing and get the tax benefit. So without this for CLTs, once a tenant goes above 80% without this legislation, that unit will no longer qualify. It will be removed.
So go to market rate at that point? Would it be a market rate rent, or?
That is kind of why this legislation, in my opinion, is important. So federal law prohibits somebody from being kicked out of a low-income housing unit if they go over 80% of AMI. But without this legislation, the developer will be in a hard position because one, they can't remove the tenant, and two, they will actually lose the welfare exemption on that unit. So this will basically give the developer a little bit more of a cushion. Since they can't remove that tenant, they will still enjoy the benefits of a low income housing status and keep that exemption. So I
kind of encourages the marketplace to continue to retain
correct
units for folks that their income may be increasing, but they're still working hard to make it all work.
Absolutely, and I think it adds a little bit of stability to the whole system too, in that these smaller fluctuations in income won't necessarily push you out until you hit a little higher limit.
Okay, that's great. Yeah, I support this. Thank
you. Of course.
All right, colleagues, are there any other questions? Sounds like we've got some universal support. I've already sent a letter. I'm asking the board to register. I think this is important as we continue to build out the Board of Equalization's brand, that we move in this direction and we move as a one body. So that's why we're the chair and our Vasquez and I are coming to you and asking for your support on this. Yeah, you're right. One letter is just one letter, but one big mighty letter from this team of elected officials, I think, also is powerful. And it's bipartisan, so let's capitalize on that opportunity to work together. Isn't that right, Mr. Gaines? Let's work together in the spirit of unity. Okay.
I'll move it.
Perfect. So let's go to public comment.
Yes.
And then we'll check in to see if there's anyone that needs a little bit of a break. Okay. So let's go ahead, Ms. Taylor, public comment.
Certainly. AT&T moderator, please let us know if there is anyone on the line who would like to make a public comment regarding this matter.
Ladies and gentlemen, if you would like to make a public comment, please press 1 then 0 at this time. One moment, we do have somebody queuing up. It'll take a moment. Just another moment. We have a comment from Christina Oatfield. Please go ahead.
Christina, can you hear us?
Members, my name is. Oh, I can hear you. Can you hear me?
Yes, we can hear you. It's good to hear your voice. Let's get your comment on the record.
Oh, great. Thank you, Chair Cohen and members. My name is Christina Oatfield, and I'm an attorney and legislative advocate representing the California Community Land Trust Network and our sister California CLT Action Organization. And these two nonprofit organizations represent 25 and counting community land trusts, or CLTs, across the state of California. And we're really pleased that Chair Cohen has already expressed her support for AB 1206. We are sponsoring the bill and working closely with Assemblymember Bennett on this bill, and we're delighted that the entire board may express its support for the legislation. The prior speakers have explained the significance of this bill. Just practically speaking, right now, if a community land trust has a welfare exemption and a resident's income goes above the income limit, say someone goes to 82% of AMI, that can result in them having to pay hundreds of dollars more in rent because suddenly we have this tax bill proportional to their rent, or sometimes we can lose the welfare exemption on the entire property. So AB 1206 rectifies this unfair situation. It applies a similar policy or the same policy to us as is already applied to low-income housing tax credit properties. So thank you very much for introducing this this item, Chair Cohen and former Chair Vasquez. We appreciate your support and hope to continue to work with you on affordable housing topics. Thank you.
Great. Appreciate your comment. Thank you for weighing in. Ms. Taylor, are there any other speakers?
Once again, if you have a question or comment, please press 1, then 0 at this time. Just one moment, please. We have nobody else at this moment.
All right, thank you very much. Colleagues, what I'd like to do is just restate the motion just for clarity. I move that we support AB 1206, AB 1206 by Assemblymember Bennett, and direct the Executive Director to send the California Legislature a letter of support in regard to Assembly Bill 1206. May I have a second on that motion?
Second.
Thank you. All right, let's take the roll.
Chair Cohen,
Yes.
Vice Chair Schaefer,
Yes.
Member Gaines,
Yes.
Member Vasquez,
Aye, yes, whatever it takes.
Deputy Controller Stowers.
Aye.
Motion passes.
All right, thank you very much. Ms. Taylor, let's take a 5-minute break and we will resume at 2:47 p.m. Thank you, ladies and gentlemen. We're taking a recess, a recess. 5. Yes. Ms. Taylor?
All right. Our next
Please.
item is L1B, Board Member and Board of Equalization Website Translation. Board discussion and possible action relating to installing the interim, related to installing in the interim a Google Translation icon and associated disclaimer to the board member and Board of Equalization websites to ensure taxpayer accessibility in various languages. This matter will be presented by Chair Cohen.
All right. Thank you very much, Ms. Taylor. Okay, colleagues, we are getting close to our closed session time, so let's move expeditiously. I want to begin by thanking the executive director, her team, and then CDTFA for the work that they're doing on a daily basis to ensure that our website is informative and user-friendly. I realize that there is a lot that goes on behind the scenes to make sure that it remains current and running properly. The reason why I placed this item on the agenda is because I believe there is a viable interim solution to begin translations on our website. Previously, I pointed out that the City and County of San Francisco, where I served, has a translate button on our website which enables visitors to receive information in their preferred language. In visiting other state agency websites, such as the governor's website as well as the Franchise Tax Board's website, I'm able to click on a translate icon and choose from a multitude of languages. I also noticed that a disclaimer window appears, which appears to mitigate liabilities associated with potential missed translations. And I realize that Google translations cannot account for all nuances in language. However, it's a viable option. It's a viable option worth considering. And according to the United States Census Bureau, California is the state with the highest percentage of people over the age of 5 who speak a language other than English at home. So approximately 44% of Californians speak another language at home other than English. So as board members and public servants, I think we have a responsibility and an obligation to actively communicate with taxpayers. It's not enough to put information on a website and hope that someone who doesn't speak English will find a way to interpret the information or find a translator on their own. The Google Translate service offers over 100 languages, and I believe that it's a service worth exploring as an agency. I'm wondering if the executive director could provide any insight on the service. As we all know, she's got a strong technology background and probably has some insight to offer. Ms. Fleming?
Thank you for the opportunity, Madam Chair. So members, Google Translate is a function that does, as the chair has noted, does provide some static ability to provide static, what we refer to as static information, and can translate that into a range of languages. So if it's something that the board is willing to look into, what I'd like to do is have my staff working with our comms chief and some of the staff along with the technology staff take a look at the feasibility of applying that feature and that function to the BOE website. As the chair noted, there's disclaimer language that almost all the state agencies that are using this function, there's disclaimer language that just informs the public in a healthy way about some of the limitations or some of the challenges with the absoluteness of the translations. We certainly don't want to misinform anyone as they're visiting our website. But as visitors come, to your point, we've got a wealth of diversity in California, including language diversity. So I think it is something that we can take a look at. We just need to look at the feasibility of how we would go about doing the implementation and being able to support it. So in lieu of some sensitivity to the time, I'm working with my comms chief to take a look at it, and with the board's approval, we can come back at an upcoming meeting, provide a little bit more detail on what's involved in the implementation of this feature and this function. It does provide some translation languages, so I think it has some benefits. We just need to, we'll work with legal to make sure that the appropriate translations are there, consistent with other agencies, but certainly doing our part to support the taxpayers and other visitors to our public-facing website. Madam Chair, back to you.
I appreciate that. Thank you so much. Colleagues, are there any remarks that you may have? Deputy Controller Stowers, I see your hand. The floor is all yours.
Thank you, ma'am. I looked at the translation, and you're absolutely right. The Franchise Tax Board has and several other agencies. I think it's looking into the feasibility for BOE is a great idea. It will definitely help with our operations and help with our communication. I know right now it was a free service, but there may be a charge in the near future. So I would like to suggest that when you're doing your investigation, seeing if we could have a joint contract with another state agency to defer some of the costs. You know, maybe
thank you for that.
CDTFA.
To see if perhaps CDTFA or some of the other agencies. And that's something that we can take a look at. That would be something similar to what we do, for example, in our Microsoft environment, where there's enterprise licensings. And so you raise that up to the statewide level to get the benefit of the entire statewide benefit. I'm being very careful to go too deep into that portion of the conversation because I've not talked to my colleagues in the IT space or the other agencies. So I certainly don't want to misspeak and put them in a position of committing to anything. But to the extent that this is something that California is offering and all state agencies are participating, there's some benefits. So we will add that, Mr. Kim, if you would make a note, we'll add that portion of the components to our analysis also in terms of implementation. And if not, you know, at a broader level, just take a look at any pros and cons and benefits of partnering with just other agencies in general. So we'd be happy to look at that.
Well, let's look at it.
Will do.
Let me see. Mr. Gaines has his hand up.
Yeah, thank you, Chair Cohen, and I agree with Member Stauer's comments. I think that's a great idea in terms of trying to do this as efficiently as we can. And I know this is an issue that Member Vasquez brought up quite a while ago, and so I'm encouraged that he brought it up, and it looks like things are moving forward, and the technology is amazing. I mean, imagine being able to translate in 100 different languages. It's really kind of a lifesaver in the sense of our ability to provide the service at a low cost. So I'm encouraged by that, and I think we ought to continue investigating it and see if it all makes sense. Thank you.
Thank you, members.
All right, thank you very much. Mr. Schaefer, you're up.
You're muted, sir.
Yeah.
Oh, am I on? Yeah. Well, I'd just like to concur with Member Gaines. I think he has a very sound view on it. My only concern has been when they start printing something in a hard paper in 20 different languages, but this is electronic and it's productive. Thank you.
Thank you, sir.
Great, thank you. So again, I just want to state that, as I stated in the memo, that I'm just asking the executive director to engage in the necessary due diligence.
Duly
So
noted.
I'm sure she'll come back and she'll tell us how much it's going to cost. Okay, fantastic.
No, Madam Chair, if you need a motion, I'll move it to get her to look at the pros and cons and hopefully come back with some real good analysis of the benefits and of this, especially I think what Ms. Dow's was saying, let's see if we can't join forces with some of these other departments within the state.
I love that, and I will accept that motion, and I will second that motion. I move and just add that we direct the executive director to explore the feasibility and the appropriateness of this interim solution. That's it. So thank you for making that motion. And for the record, I'm going to second that motion, Ms. Taylor. Let's pivot and go to public comment.
Yes, AT&T moderator, could you please let us know if there is anyone on the line who would like to make a comment on this matter?
Ladies and gentlemen, if you would like to make a comment on this matter, please press 1 then 0 at this time. Currently, you have nobody queuing up for comment.
All right, thank you very much. May we take a vote on this motion, Ms. Taylor?
Yes. Chair Cohen?
Aye.
Vice Chair Schaefer?
Aye.
Member Gaines? Member Gaines? Member Vasquez?
Aye.
Deputy Controller Stowers.
Aye.
Let me go back and see if Mr. Gaines is available to vote. The motion passes.
All right, thank you very much. Appreciate that. Ms. Fleming, just want to check in with you. It is almost 3 o'clock. Shall we pivot to closed session now, or shall we continue with the agenda until we get to the closed session?
Well, I would recommend at this point, because we do have invited guests, ma'am, here to present. So if you wanted to, one option is that you could proceed to the guest on the M item and move the board member strategic plan. We can shift things around.
Okay.
Or if you want to go to closed session, that is an option. We come back after closed session and resume the items. I'm just sensitive to the invited guest.
All right, I'm going to take your recommendation. Let's go ahead and move to the M items. We'll have our guests. We will skip L2A. We'll go to M1. Ms. Taylor, can you call that item, please?
Yes. Our next item is M1, Public Policy Hearings, discussion on the implementation of Proposition 19, the Home Protection for Seniors, Severely Disabled, Families, and Victims of Wildfire or Natural Disasters Act of 2020. There are no staff reports or external speakers for this agenda item. However, persons who wish to address the board on this topic as a public comment may do so. This is an information-only item. Would you like me to move to the AT&T moderator?
Yes, please.
AT&T moderator, please let us know if there is anyone on the line who would like to make a public comment on this matter.
Ladies and gentlemen, if you would like to make a public comment at this time, please press 1 then 0. Currently, we have nobody queuing up for comment.
Great, thank you very much. This is an information item, so let's call the next item.
Yes, the next item is M2A, Public Policy Hearings. Impact of public calamities on property tax administration, county boards of equalization, assessment appeals board, AAB remote hearings, lessons learned presentations. There'll be 2 presentations. The first will be with Edward Yen, Assistant Executive Officer, Technology, Planning and Operations, Executive Office of the Los Angeles County Board of Supervisors, and co-presenting with him, Jennifer Tran, Acting Deputy Executive Officer, Los Angeles County Assessment Appeals Board, and Alina Kasparian, Acting Assistant Chief, Assessment Los Angeles County Appeals Board. And when their presentation concludes, we will also hear from Ann Moore, Chief Deputy Clerk, San Diego County Board of Supervisors.
Thank you. All right, let's go ahead and begin. I want to welcome all of our guests. Thank you for being here. I appreciate your presentation. This is
Madam Chair, you want me to cue it up?
Yeah, please go ahead.
Okay, let me go ahead and cue it up. Chair, this is Chair Cohen, and for the members, I would like to welcome Mr. Yan and Mrs. Alina Kasparian. Mr. Yan contacted my office several months ago, offering to provide us with a presentation on the county's virtual hearing system and the AAB platform that his office developed to effectively and efficiently address document submission and simultaneously viewing problems in remote AAB hearings. I am very supportive, and I have already committed to working with his office on some next steps that may help other counties with their modernization efforts. So thank you, Mr. Yan and Ms. Kasparian, for your time and investment in preparing for this board presentation, and welcome. I'll turn it over to, are you going to start Mr. Yan first, or?
I will.
Okay.
All right. Well, thank you. Good afternoon, members of the board. My name is Edward Yan, representing the Executive Office for the County of Los Angeles. I am the Assistant Executive Officer overseeing the Assessment Appeals Board. Presenting with me today are Jennifer Tran and Alina Kasparian. I want to thank Chair Cohen and Board Member Vasquez for inviting LA County to share our virtual hearing platform experiences. We are proud of our employees' efforts to build and implement this customized solution that allowed our county to continue scheduling assessment appeal applications during the COVID pandemic, thus providing taxpayers their due process rights to a hearing. Based on our experiences with virtual hearing, we are eager to continue to offer this platform in our post-pandemic plans. During this past year, your board, in collaboration with various stakeholders, including assessors, assessment appeals boards, applicant representatives, and attorneys, held meetings to finalize guidance for counties to implement virtual assessment appeals board hearings. While many stakeholders were eager to continue with hearings, some counties were hesitant or unable to virtually hold hearings due to a lack of financial or human resources. Due to LA County's enormous caseload, we determined to quickly move forward with developing a custom-built document exchange platform and commence virtual hearings on October 19, 2020. Today, I will be explaining some of the reasons why LA County quickly transitioned to a virtual hearing platform and describe some of the benefits we found moving to virtual. Ms. Tran will be discussing how we built our platform while also describing how we resolved concerns that were raised by stakeholders. Ms. Kasparian will then conclude by providing examples of what our virtual hearing platform looks like and provide a guide to how to access the document exchange platform while also providing views that users have on their screens during a hearing. We hope that this presentation will provide confidence to other counties to consider using virtual hearings as another method to ensure taxpayers the opportunity to be heard. Lastly, we encourage county assessment appeals boards and their IT staff to reach out to us as we are enthusiastic to share the lessons we learned from building our platform. And go to the next slide, please. So why did we go virtual? Back in March 2020, LA County closed all county facilities to prevent the spread of the COVID-19 virus. This also effectively suspended the scheduling of assessment appeals board hearings, causing an increase of open applications. During the suspension of assessment appeals board hearings, our open applications increased approximately 25 to 35,000 applications, about a 30% increase from the same date the previous year. We determined waiting to schedule hearings would only increase the backlog of open applications and impact the taxpayers' rights to a timely appeal. I just want to quickly note that in our slide presentation, we identified 37% increase. I just want to make sure that people know that that was a misnumber and that should actually say 27%. So during the early days of the pandemic, our executive officer, Celia Zavala, directed our information technology team and assessment board staff to research technology platforms suitable for us to quickly provide virtual hearings. No cost-effective solutions were identified, so our IT staff, led by Amin Al-Muhajab and our PR Nazarian, designed a platform that used WebEx to broadcast the hearing online. Although WebEx, Teams, or Zoom are considered commonplace nowadays, at the time, WebEx was the only platform that allowed us to scale the usage of virtual conferencing. Most importantly, though, was the development of our custom-built assessment appeals portal, or as we like to call it, AAP, for evidence to be submitted online, which would allow parties to share and display evidence during a virtual hearing. Due to the customized platform, we were able to keep costs lower and quickly transition to an effective virtual hearing solution. We conducted our first virtual hearing on October 19th, 2020, and we haven't turned back. Next slide, please. So some of the benefits that we found through virtual hearing, and we quickly found out, was we addressed the health and safety of participants by allowing parties to use their existing technology equipment, such as computers, smart device, or tablets to attend a hearing in the safety of their own home. Second, we needed to address the issue of exchanging information, which we resolved by creating the Assessment Appeals Portal, which allowed for convenient online evidence uploading to allow participants time savings and money for making multiple copies of exhibits. When some exhibits can total hundreds of pages, this was actually a great cost savings for them. Third, we also found that board members, taxpayers, representatives, and assessor representatives would have timely arrived at their scheduled hearings due to the accessibility of just logging onto a computer to attend a hearing instead of driving sometimes 2 hours just to attend a hearing in downtown LA. We have also found that virtual hearings was not a deterrent for parties to attend. From October 2020 to October 2021, we have scheduled 25,934 applications for virtual hearing, with only only 467 requesting to appear for in-person hearings. This has helped our county to continue to efficiently schedule hearings to reduce our open applications. Next, we also found that the virtual hearings has helped taxpayers, representatives, and county employees save money from commuting costs such as gas consumption and parking fees incurred when appearing in person. And finally, the virtual hearing platform allows us to record the hearing to offer high-quality audio and video recordings when requested, which are much better than the audio recordings we previously offered. Next, I would like to introduce Jennifer Tran to discuss how we developed our platform.
Thank you, Mr. Yan. Good afternoon, honorable board members. My name is Jennifer Tran, the Acting Deputy Executive Officer for the Los Angeles County Assessment Appeals Board. When LA County began to plan for a virtual hearing solution, our goal is to leverage current and emerging technologies to streamline processes and consider taxpayers' concerns on virtual hearing implementation as shown on this slide. First, we allow applicants to request for in-person hearing in lieu of a virtual hearing. We modified our internal system to include a system flag to help us identify and track applications with in-person hearing requests. Second, we implemented an electronic submission process where evidence is submitted at least 2 days prior to the hearing date, allowing both parties to view and download each other's evidence at the hearing. For taxpayers who do not have capabilities to digitize documents, documents may be sent to AAB at least 1 week prior to the hearing for digitization. The system also allows for submitting rebuttal evidence at the hearing and simultaneous side-by-side view for document comparison. Lastly, based on our recent survey, AAB members' availability have increased by 26% due to the convenience of virtual hearings. Also, since there is no commute or traffic conditions driving to downtown LA, hearings start promptly as scheduled. And finally, our virtual hearing platform offers the use of virtual breakout rooms for private discussions and deliberations. Next slide, please. As shown on the Venn diagram, LA County's virtual hearing solution is comprised of 2 systems using current web conferencing technology and a highly customized evidence submission system. First is our virtual meeting platform, as shown on the right side of the diagram. Using WebEx, evidence is shared or displayed at the hearing. Virtual breakout room is used for private discussions or deliberations, and customized view of participants, including pinning specific persons based on user preference. Although LA County uses WebEx, as mentioned by Mr. Yan, there are other web conference tools available with similar functionalities, such as Zoom or Microsoft Teams. On the left side of the diagram is the Assessment Appeals Portal, or AAP. AAP is the critical component of our virtual hearing solution. It is a highly customized, innovative, and interactive document management system that provides a safe and secured online portal to streamline the evidence submission and document sharing processes. Under a tight and aggressive timeline, AAB and our IT team worked diligently during the customization, testing, and integration of the following 3 technologies. First, we customized the Box application to serve as our centralized document repository of digitized hearing evidence. Once an application is scheduled, the information in AAP is updated, allowing the applicant and the assessor to view their upcoming hearings and upload their evidence into the portal. All parties can simultaneously view the documents once they are made public by the AAB clerk. Access to the evidence that were made public at the hearing is available through the end of the hearing date. Second, using an automated email notification system called SendGrid, email reminders are sent to both parties to upload their hearing documents with the link to the AAP portal. The system also allows us to track the delivery receipt of the email reminders. And lastly, using Microsoft Power BI as our data analytics tool, we are able to create various reports on portal logins, file uploads, file access, and other metrics. Next slide, please. To ensure a smooth transition from in-person to virtual hearing, LA County provided the following pre and post implementation support. First, as part of our communication and outreach efforts, we developed informative video clips and tutorials that are available on our website and also accessible on YouTube. Similar information is also provided or shared during the monthly virtual public education seminar, which is designed to educate the taxpayers on assessment appeals process. Informative flyer is also enclosed with the mailing or the mailed hearing appointment cards, which includes information on how to access the detailed step-by-step reference guides on our website. Email notifications for WebEx meeting invitation are sent out to the applicant at least 1 week prior to the scheduled hearing. Second, multiple training sessions were provided to our AAB board members, hearing officers, AAB staff, and assessor staff. Also, practice or dry runs are available for taxpayers and agents upon request for training or connectivity test purposes. Lastly, we offer a web conference room located at the Hall of Administration for taxpayers who do not have the required equipment to participate in the virtual hearing. This private, safe, and secured room is fully equipped with web conferencing technology, including PC and monitor, webcam, scanner or printer, and internet connection. We also provide on-site technical support if needed. And now I'll turn it over to Ms. Alina Kasparian, who will provide more information on our virtual hearing process.
Thank you, Jennifer. Appreciate it. Good afternoon, Chair Cohen and members of the board. Thank you for this opportunity. I'm just going to jump right in for the sake of time. So this screen is displaying 5 icons or images giving an overview of the virtual hearing process. The first icon is at the beginning process where an application is actually scheduled for hearing. The second icon is of appointment cards and virtual hearing instructions, which are now mailed and included to give instructions to taxpayers on how to register and upload documents in our AAP portal system. The third icon is of a WebEx, which basically says that we send out WebEx invitations at least 1 week prior to the hearing to all taxpayers and tax agents. The fourth icon pertains to the AAP portal, in which taxpayers, tax agents can upload their evidence, and they are encouraged to upload evidence at least 2 days prior to the hearing, consistent with this board's LTA. And as mentioned previously, taxpayers have the ability to upload documents as soon as their case is scheduled, giving them plenty of time prior to the hearing. Lastly, the fifth icon is the attending of the hearing, which is done virtually online at hearing. This slide displays 4 icons to illustrate what taxpayers will need for virtual hearings. The first one is a PC or a laptop. Second one is any smart device such as an iPhone. The third icon is of internet connection. And fourth is access to audio video capabilities. This slide displays 4 icons illustrating the AAP portal process for uploading hearing evidence. So all users must complete a one-time registration through our AAP portal. Once they create their username and password, which is their email and their password that's unique to them, they log into the AAP portal. They are able to select their case or hearing or particular application to upload their evidence. And once they're in that particular case, they can upload their evidence. This screen displays a short clip of the AAP portal and how taxpayers sign in to upload their evidence. Demonstrated on this screen, the applicant will log in using their username and password they've created. They will select their upcoming hearing, click on the document button, and once they come into that actual case, they can click on that little plus sign, hit upload. They can browse their device or even drag and drop if it's a file that's on their desktop. You can select multiple documents, click upload. You can even tag the documents up top, such as like confidential, to notify the clerk, and click upload. You can also preview what you've uploaded just to make sure it's the right document. So you could click on the file that you've uploaded. And then you can continue to upload additional documents, or if you prefer, you can upload everything at once by selecting multiple files once you browse your device. And again, you can preview all of your documents. You can also save and download on your desktop as well, but you already have those files on your desktop. So this particular screen is of another short clip of our AAP portal and how documents are viewed or saved during the day of the hearing. So again, the user will log into their AAP portal using their username and password that they've created. Select the upcoming hearing they would like to upload or view documents at the day of the hearing. Click on Documents. Up top, there are 2 buttons, the View Public Files and My Files. The View Public Files button is basically documents at hearing that are made available by the clerk, marking it as public, which means all parties are able to see both the assessor and the taxpayer. If the document is not marked public, the other party cannot see the taxpayer's or assessor's documentation or vice versa. And My Files tab will basically allow you to see your own files if you are the taxpayer, and the assessor if you're the assessor. This slide displays 2 screenshots of WebEx layouts that taxpayers can utilize during the day of their hearing, depending on whatever your preference is. So you simply can click on the layout button in WebEx and customize whichever view you want. So the screenshot on the left, I want to point out, shows 7 participants displayed at the top of the WebEx app, with the document that's being shared on the screen as a primary focus. This view allows taxpayers to toggle between the participants at the top. So you can move over, whichever participant you want. If there's additional participants that are not listed at the top, you can simply toggle between them and move them for your primary focus right above the document that you're viewing. The screenshot on the right shows another layout option that still displays the document on the left, but also gives the taxpayer the ability to do what's called pinning the participants in the center to the right of the document, which displays a larger, more focused image of the participants. The remaining participants in the hearing are displayed all the way to the right of the WebEx app with the ability to view and move around those participants for viewing. So in this particular case, this individual has pinned the 3 board members and the assessor's representative, who's highlighted. The box has a little highlight around them, which means that individual is currently speaking. The person who's speaking is always in your focus, no matter what view you're in. And this is some, taxpayers' preference where they want to simply focus on the board member and their reaction, and that's just as fine. The other neat thing that I would like to point out is that the person who's, other than the person who's speaking being highlighted, WebEx will always notify you at the top of the screen the person that is speaking. So if it's the assessor's representative, it'll say Mr. Chepian in this case is speaking. WebEx also allows you to mute and unmute in the same screen, which makes it easy and convenient for the person to follow along and speak in the same view as well without having to change their layout or make any other modifications. This slide, as well as the next 2 slides, include some samples of actual virtual hearing recordings. I would like to point out that since the AAB clerk has recorded these hearings, the video displays the clerk's view, which generally focuses on the document, since the clerk's primary responsibility is to share the document that's being requested from either party. So this particular slide demonstrates the agent and applicant testimony. The 5 hearing participants are displayed at the top of the screen, which includes the clerk, the assessor's representative, Mr. Tovar, and the agent, Mr. Nichols, who are interacting and speaking, as well as the board members and the appraiser. The agent also calls on the applicant, Mr. Kader, to speak, and the evidence being displayed is the primary focus of the screen. So please let me know if you are unable to hear the audio from this video clip.
So here's some of the purchase price issues. The property was valued consistently and purchased based on a long-term commitments of key tenants such as Starbucks. The issue here is the appropriate risk level were not accounted for on the non-credit grade tenants. The result of this action was an overvaluation of subject property due to lack of consideration of possible significant vacancy in the future. As well as in our opinion, the capitalization rate paid was considerably below market. Mr. Pinder, can you hear us okay?
Yeah, I can hear you very good. Yes. Can you hear me?
Great. Yes. Can you state your name for the board?
My name is David Kedea.
Okay. And are you the owner and of this property? You're that purchased the property, correct?
Yes.
So I would like to point out that as soon as the taxpayer was called upon by the agent, even though he was originally not in focus, the person who's speaking will always come into focus no matter what view the individual has. As you can see in Mr. Kader, as soon as he spoke, you saw his icon or his face is displayed at the top. This slide displays another sample video recording of a virtual hearing demonstrating the redirect of the testifying appraiser. The slide displays the 7 participants, the clerk, the assessor's representative, Mr. Tovar, who is speaking and questioning his appraiser, the 3 board members, the agent, and the appraiser, Mr. Martin, who is also speaking.
The second sentence says, it is the preferred approach for the appraisal of improved properties and personal property when reliable sales data are not available and the cost approach are unreliable because the reproducible property has suffered considerable physical depreciation or functional obsolescence.
Okay. Yeah, there you go.
Did you feel you had enough market data to support your opinion of value?
Yeah, and I felt like the 2 approaches, supported one another, so that's why I weighted them the way I did.
So again, since this is from the clerk's view and as a recording, but in live virtual hearings, Mr. Martin, once he was speaking or responding back to the assessor's representative, the box around his face or his image would be highlighted in blue so that it clearly demonstrates who is speaking and also lists it at the top. This slide displays a video recording of an actual virtual hearing that demonstrates the agent's rebuttal evidence that is uploaded and displayed in the middle of the hearing. The 7 participants are displayed. The chair, Maggie Soleimani, inquires if the agent, Mr. Boyle, has rebuttal evidence, to which the agent indicates that he does. And I just want to point out that anytime there's any rebuttal evidence that is going to be presented, the chair will always provide ample time for either party to pause the hearing, take a break while the person uploads their documents.
Mr. Boyle, anything in rebuttal?
Thank you, Madam Chair. Yes, we've uploaded a couple of 2 documents for rebuttal. If we could start with applicant's exhibit, we will go with Exhibit C, which is labeled Assessor's Handbook 502.
So at this time, the chair has already provided time for Mr. Boyle to upload that rebuttal evidence. I believe it was about a 15-minute break since the documents are readily available. So the clerk is right now logging into the AAP portal as the clerk's role and to pull up the documents, mark it as public so that all parties are able to see the documents.
The applicant's Exhibit C on screen.
Thank you. Could you flip to page 4 of the exhibit? It's a highlight of the text that was referred to in our case earlier related to effective rents under Assessor's Handbook 502. And this is under the header of estimating. If you actually go up 1 page just to make sure we're clear on what subject title this is under, this is under the header of estimating market potential gross income.
And finally, this slide displays a screenshot of our Assessment Appeals Board website, which includes user guides on how to navigate WebEx, as well as our AAP portal. We also have other informative material. We do have short clip videos, kind of like some of the ones I've demonstrated in this presentation on how-tos. We are also, under Eddie Yen's direction, we are also working on revamping our website to make it more user-friendly. And adding a lot more resources that can assist our taxpayers with preparing for their appeals. And this final slide concludes our presentation. And on behalf of LA County, I want to thank you for your time and this opportunity. I appreciate it.
Thank you.
I appreciate that. I'm sorry, Mr. Vasquez. This presentation has been great. I've been waiting on it since last month. So Mr. Vasquez, I'll go ahead and let you finish up your comments. I just had to say good job to the presenting team.
No, I really appreciate your patience with this, and I know you folks spent a lot of time just preparing this, and I just wanted to thank you. I think you I was going to open up with a couple of quick questions, but I think you answered 2 of them. But the third one, I'm not sure you really touched on, and that is what type of maintenance support is needed for this system, and would it be costly for other counties, I guess?
So, right, like we said in the beginning, this is a custom-built system, and we have internal staff that we have providing the maintenance and support. I think the idea would be that if a county has their own IT technology team, we would be able to share the resources and the plans and the logistics of how we prepared. And then it's just a matter of finding out what type of resources another county would have in order to try to onboard a system like this. But we don't really have it's really difficult to identify the actual cost because, we're just internally developing it. So it's whatever time spent on developing it. And then as far as the actual cost of the software that we're using, for example, with Box or WebEx, we've approximated that the cost could be anywhere from $30,000 to $45,000 annually. But we're still trying to identify and pinpoint the cost because there's a lot of licensing that's based on enterprise licensing from the county as a whole, and then try to pinpoint only our department. It kind of requires some digging into the numbers.
Thank you. Is there any other members or any members on our board that have any questions after hearing and seeing the presentation?
Come on, did you see that presentation? No questions, no feedback, no comment. I mean, that was exciting.
Good stuff.
Yeah.
I could comment on it.
Sure, go ahead.
My concern as an elected who represents a lot of rural California, I mean, I can tell you personally that I don't have the greatest internet service at my home, and I've got hundreds of thousands of constituents that don't, and this option simply would not work. And so it concerns me if we're not giving taxpayers an option in terms of how they can present their case. I like the presentation. The presentation was great. I think you've got great technology. It probably works very well in LA County. But, I represent 30 counties and a lot of them are rural. And I'm going to represent 34 if I have the honor of being reelected. So that's a real concern I continue to have. And maybe things will get better with Elon Musk and his new technology of launching satellites for better internet in rural areas.
No, definitely. And I think the purpose for our presentation is merely to show and demonstrate one technology that has been used out there. And definitely internet connectivity is a big issue. And we definitely agree with you with that. And hopefully, this is something as just one tool, one platform that is available. And we are open to any other counties wanting to discuss with us, and we're willing to share our lessons learned.
Thank you. I appreciate that.
Well, okay.
Seeing no other hands or comments, Madam Chair, let me just give
I'm
my
sorry,
closing remarks.
I didn't hear you. What did you say?
I'm sorry. I said, seeing no other hands, I will, if you wish, I will go ahead and give some concluding remarks, and then you can go from there.
I believe we also, excuse me, Chair Cohen, we also have Ms. Ann Moore, Chief Deputy Clerk from San Diego County Board of Supervisors.
Yes.
I'm sorry, go ahead. I thought she was there for a resource. Go ahead.
No, it's very hard to follow LA in that presentation. But good afternoon, everybody. I am Ann Moore. I'm the Chief Deputy Clerk of the Board of Supervisors for San Diego County, and my assessor's office actually graciously volunteered me to speak to you today about how we transitioned to virtual hearings with the opposite experience of LA. We had limited additional technical resources. So we implemented virtual hearings a lot earlier. We went with all of our administrative hearings in May of 2020, and then we had our first virtual hearings with applicants in July of 2020. We transitioned shortly after our Board of Supervisors meetings transitioned, and overall the experience and process has been very similar to our in-person hearings, but do require additional efforts from our team that I'm just going to touch on in brief, because we don't have as many technical resources. So when it became apparent in the early days of the pandemic that the situation necessitated virtual hearings, we looked into many of the virtual platforms available, including Teams, BlueJeans, WebEx, GoTo. We ended up selecting Zoom after our Board of Supervisors had success with it, but we also looked at the functionality and ended up choosing a different license type of Zoom than our board meetings did. Functionality that we had looked for was a waiting room, breakout rooms, enhanced mute functionality, so the ability for us to mute people and have the muting stick versus them being able to immediately unmute. Alternate host functionality, as well as a platform that easily supported both call-in and web access. So when we schedule our meetings in Zoom, we create this Zoom meeting using a password and a waiting room, and we use the option to mute participants upon entry so there's no interruption in the record if somebody joins mid-hearing and forgets to mute. We also plan for additional prep time for our staff so we can do additional testing prior to the board and parties joining. Of course, prior to the meeting, we post detailed instructions similar to LA County on how to join the hearing on our website, and we send an email to all the parties with the link as well as to the board. We also send instructions with our notices. And also, like Los Angeles, we conducted mock hearings ahead of scheduled hearings. And this was, I can't recommend this enough. It allowed everybody, including our team, to get more comfortable with the platform. We allowed practice for setting up the screen or view settings, going into and coming out of breakout rooms, allowing additional moments for parties to object, adjusting Zoom on their screens so that those who may want larger views could zoom into exhibits, etc. And again, this was absolutely invaluable, and I encourage anybody who's just moving into virtual to do these dry runs ahead of time. In the actual hearing, our board members have Zoomed in from their own offices or homes. We also know that some counties, based on their own county health department guidelines, have held hearings with the board in one room with the clerk, but the parties join virtually. We don't hold hearings where only one party is virtual. Our calendars are either set as in-person hearings or virtual, but we don't do any hybrid. And we found that with our limited additional technical resources, that the most successful hearings, we need to have 3 staff members devoted to the meeting. So we have a main clerk who is, basically the clerk who would be in the room for an in-person hearing. So they do all the setup and coordinate the logistics of the meeting. They facilitate the meeting. But then we also have a secondary clerk who's also in the meeting, who's there to help with the exhibits, the breakout rooms, muting, checking in parties, and dealing with any late submissions. We also have a third clerk who's not in the meeting, but who is assigned to take phone calls and respond to emails to help parties or others trying to join the meeting and to work through technical issues. We found that the technical issues that we experienced are usually due to inexperience with technology, or they didn't read the instructions. When our staff starts the meeting, they rename themselves similar to how you saw in the video to indicate that they're clerk of the board staff. So when they speak, it's clear that to the parties and in the record of who's speaking. At the beginning of the hearing, our main clerk has a script that they read that details all the mitigation factors that we have for additional virtual hearing logistics. And then our team works together in kind of this choreographed effort to ensure everything is shared and distributed promptly when needed, and that members and parties are dropped into breakout rooms quickly when required. This is where the additional clerk of the board staff has proved essential. They use mute functionality as appropriate to ensure that the record is clear, and we found that the Zoom records are much more complete without the additional background noise that a large room of attendees creates. If for whatever reason a party or a witness has technical issues or drops out during the hearing, we collect phone numbers prior to the hearing for all of our parties, and our secondary clerk immediately gets the dropped party on the phone to troubleshoot and resolve the issue. This hasn't happened in a while. We saw it more frequently in the beginning of the pandemic when there were bandwidth and infrastructure issues due to so many people moving to telecommuting. But having this process in place ensures that we can immediately contact them to prevent any issues with the hearing due to the continuity. We also keep a county issued cell phone or a hotspot available during the hearing. We did have one occurrence where it was actually the county network that went down, but we were able to quickly bring the meeting back up because we held the hotspot on hand. I know I've touched on this in previous presentations to the board, but briefly, evidence is submitted via email, and we ask for it 72 hours in advance. We were also early on using email for distribution at the time of the hearing, but we found that we were having issues with delayed receipt or no receipt due to the size of some of the exhibits. So after doing some research on what other counties were doing, as well as what courts were using for evidence submission, we transitioned to using Dropbox. So parties submit their exhibits via email or mail or whatever method they choose, and we collect and consolidate them into a Dropbox folder specific for the hearing. Then at the time of the hearing, we're able to share a read-only link to that Dropbox folder that includes all the exhibits for that application, eliminating issues due to file size. It reduced a lot of confusion and delay due to board members searching through multiple emails per case trying to find the exhibits being discussed. Rebuttal exhibits can be quickly processed by our secondary clerk during the hearing and dropped into that same folder. When exhibits are presented in the hearing, our main clerk shares the exhibit on the screen and navigates through at the direction of the submitting party, similar to how you saw in LA's video. We've had feedback that some parties would prefer to share their own exhibits, but having the clerk control it ensures that only the exhibits that were filed and distributed are shown. It also limits the risk of showing exhibits that were not admitted, personal files that shouldn't be shown, or any notes that the party might have open on their desktop, among other things. It doesn't limit the party from being able to show what they wish to. In fact, instead of spending time trying to direct board members to the correct page in a stack of paper that they've filed, which is not inconsequential as far as timing during in-person hearings, it ensures that everybody is looking at the exact piece of evidence that they want them to. And then a final note on trade secrets. For hearings where there is issue of trade secrets has been raised, we distribute the link and password only to parties, and then we use the feature, the waiting room feature in Zoom, to only admit named parties and their witnesses at the appropriate time. These practices have worked extremely well for us. We haven't had, much of a budget for additional technical platforms, but we continue to refine the process as we learn more. We're also keeping tabs on any new practices that either the courts or other assessment appeal boards are implementing that we may want to consider. But overall, we've been extremely successful with this process and the mitigation techniques that I just touched on. Out of the approximately 5,000 hearings that we scheduled during our virtual only period, only 28 hearings were continued upon the request of parties to an in-person hearing. So I will just keep it brief at that. Thanks for the opportunity to speak again about this today. I felt it was important to impart that successful virtual hearings can also be conducted with minimal, technological resources. Because I do know that there are counties that just don't have the resources to do so. It's just a matter of having clear, conscious procedural best practices in place. So again, thank you for your time.
No, thank you for sharing. And I see there's two hands up, Madam Chair. Let me go ahead and call Mr. O'Neill, I believe has a hands up.
Yes, thank you, Member Vasquez. Chris O'Neill. I'm an attorney in Los Angeles, practicing exclusively in the property tax area, and have appeared in front of assessment appeals boards for almost 30 years now. And I would like to respond to the presentation that was made by Los Angeles County. First of all, to say that it's very informative. And to say, and by the way, I'm speaking on behalf of CATA, the California Alliance of Taxpayer Advocates. I'm part of a special committee that is addressing State Board of Equalization issues as they're raised during 2022. So going back to Los Angeles County and the presentation, you can't deny that Los Angeles County has developed an approach, a pretty sophisticated approach using the WebEx platform that works well in a lot of circumstances. And I would say it's worked well, especially during the pandemic, because the cases that aren't appropriate for.
Excuse me, Mr. O'Neill. Mr.
Yes.
O'Neill, excuse me, this is Ms. Taylor, the clerk. We have lost our sound with AT&T, so we'll have to take a brief moment, perhaps 5 minutes, to solve our technology problem.
Okay.
Speaking of technology, here we are. Okay. So we'll have to take a pause here. Hopefully we get reconnected here in the next 5-10 minutes here.
Okay.
So thank you for that, members, and thank you for staff. We'll look into it, and Madam Chair and members will keep you posted and try to get this issue resolved as quickly as we can. Thank you for your patience.
well. And if there's a single witness on each side, I think that works well. And there's no doubt it's a, assuming your internet is working, it's a good approach for those types of matters. As the number of documents increases, as the number of witnesses increases, as the number of hearing participants increases, it becomes more problematic. Moving between documents, in my experience, even on LA system, is slow and cumbersome. The ability to see all documents simultaneously is hard. You need multiple screens. The ability to see all witnesses or all participants, you can't do it. You have to toggle back and forth across the top. And also, oftentimes, the person who is speaking is very small on the screen. And to determine whether or not, there's truthfulness, which is the reason for the hearing, if there's witness coaching going on in the room, it's very difficult to tell. Turning to page 4 of the PowerPoint presentation that was presented by Mr. Yen, Kata would agree with the information on page 4 or slide 4, PDF page 4 of the PowerPoint, and in particular the right to in-person hearings. We are pleased to see that Los Angeles is agreeing that there should be a right to an in-person hearing in lieu of a virtual hearing, because I think undoubtedly there are going to be cases which just don't lend themselves to virtual hearings. And I'll tell you right now, all of my large hearings are on hold. I thought I heard maybe Mr. Yen say that LA will resume in-person hearings in October of this year. I'm looking forward to that because all of the major matters that I am involved with and many of my colleagues are waiting for the board in LA to reopen in-person hearings. So those are the comments I have, and I know my colleague, Mr. Donald from CADA, also has some comments he'd like to make.
Yes, hi. My name is Scott Donald. I am with CADA. I am a tax representative for the last 29 years. Prior to that, I was an assessor with Los Angeles County Assessor's Office. And first of all, I want to thank both offices or both counties for taking the time to present. I appreciate pursuit of best practices. On behalf of San Diego, there, Ms. Moore, and her presentation and going through step by step, verbally, but I totally got exactly what she was saying and how they converted back in August of last year to virtual and giving us the flexibility to pursue both. The bulk of our hearings are satisfied virtually. They've gone well in Los Angeles as well as a couple other counties. We have had some situations with audit appeals, for example, 4-year audits on some manufacturing where we do need to get in person. So with that being said, I did have a couple comments regarding the Los Angeles presentation. First, just a quick commentary on page 2 of the presentation. Whether it was 27 or 37% increase, I believe that would be expected in a year where we're transitioning to an unknown economic decline through a pandemic. So I would expect that because we didn't know if misfortune calamity is going to be applied. We didn't know a lot of factors, and I think all of us on all levels. So secondly, as my counterpart, Mr. O'Neill, stated on page 4, I appreciate that opportunity for those few that we need in person on that first bullet. I would like to know the detail in terms of timing. Is it an automatic at the day of the hearing? Is there going to be some kind of requirement 7 days, 2 days, 4 days, work days before? So just a little bit more detail on that bullet would be great. Really appreciate it. And then finally, my last point, I'd like to bring up, I used to work in Los Angeles in Old Region 2, which was Newhall. And Member Gaines brought up a great point about connectivity. I still have family up there, and they still have connectivity problems, and that's Los Angeles County. So whether it's the Santa Monica Mountains, we have friends out there, parts of the San Gabriel Mountains going up there, or out in Castaic and those areas, and even in the Antelope Valley, just in Los Angeles County, there can't be connectivity. So I think that lends itself as well to a virtual flexibility with in person. And thank you so much, everyone, for your time today. That's it.
Thank you.
Thank you.
Was that, I thought I heard somebody else. No, thank you all, and thank you for your patience. As you can see, technology, sometimes it doesn't always work for everybody. I mean, I'm even experiencing some lighting issues where I'm at right now. So I'm coming out a little bit dark on the screen here. Hopefully you could see me, but anyway, if there's no other comments from any of the members or other participants that have weighed in on this, I would just like to thank specifically Mr. Yan and Ms. Gasparian for your work and your hard patience, especially in creating this platform. And like I mentioned in my opening remarks, we're going to continue to work on this here, at least in LA County. And I think it was Member Gaines mentioned, you know, it obviously probably is not something that might be suitable or even compatible with some of these smaller counties because they just don't have the resources or the technology. And I get that. At the end of the day, we're hoping that we can create this model, at least here in LA, that some of the larger counties could definitely use, and possibly even some of the medium-sized ones. And at the end of the day, if there's any piece of this or even parts of this platform that might be useful for even in the small counties, you know, whatever we can do to assist or help, maybe even obtain some of those resources, by all means, let's see if we can't work it out and try to make it a benefit for all 58 counties throughout the state of California. Madam Chair, I'll put it back over to you. I think you're muted though.
You're right. Thank you. I appreciate that. Thanks for guiding this portion of the conversation. It's been really interesting. And I'm glad Mr. Yin reached out to pull everything together. I would like to see if there's any public comment.
Thank you. AT&T moderator, please let us know if there is anyone on the line who would like to make a public comment regarding this matter.
Ladies and gentlemen, if you wish to make a comment, you can press 1 then 0 at this time. Currently, we have nobody queued up for comment.
Okay, fair enough. Colleagues, what I'd like to do is continue to move forward. We've heard, this is not a action item. Yeah, this is just a hearing. So what I'd like to do is go into closed session. It's 4:05. We're actually an hour behind on our closed session agenda. And also wanted to get a temperature read on, Ms. Taylor, can you tell me what is left on the outstanding balance of the agenda?
Certainly. First, we have L2A, the board member initiatives, board member strategic plan. And then we have M2B, which is public policy hearings, AAB, follow up on non-consensus items. And then we have N, public comment on matters not on the agenda.
Okay. Do we have guests for M2B? Are they here?
I'm not aware of any invited specific guests for that item.
I don't believe so, ma'am.
Okay, thank you. So let's, colleagues, how do you feel if we were to hear next month the strategic plan, the L2A item?
I support that, Madam Chair.
Okay, thank you. Okay, so okay, good. So I'm going to make a motion that we hear L2A, the strategic plan, in next month's hearing, our next month's meeting. Do I, and just in terms of procedure, I don't know. I think I can just direct. I don't think we actually need a motion. Is that correct, Ms. Fleming?
I think it's safe to have the motion just for public record. It could be done very quickly, and then a vote by consensus would be appropriate. Staff, please correct me if there's any concerns from a parliamentary procedure. But ma'am,
okay, that's fine. So I made the motion. Mr. Vasquez has made a second. Let's go ahead and take public comment, and then we'll take a vote.
AT&T operator, please let us know if there is anyone on the line who would like to make a public comment regarding this matter at this time.
Once again, if you would like to make a comment On this matter, please press 1 then 0 at this time. Currently, we have nobody queued up for comment.
All right, thank you. Let's please call the roll for the vote.
Question if I could before the vote. This is
yes,
Member
sir.
Gaines. And can you clarify what we're voting for?
Oh, sure, no problem. We're not really taking an action vote. What I'm doing is I'm trying to, our day is running out of time. And so I'm taking something off the agenda, the strategic plan, and putting it on the agenda for next month.
Thank you.
So we will still hear the item, but we'll just have to postpone it one more month. Okay, so that's the vote that we're getting ready to take. Ms. Taylor, please call the roll.
Chair Cohen,
Aye.
Vice Chair Schaefer,
Aye.
Member Gaines,
Aye.
Member Vasquez,
Aye.
Deputy Controller Stowers.
Aye.
Motion passes.
Okay, thank you. Member Vasquez, this is to you. M2B, do you think that that's a hearing that we should do today, or should we do that next month as well?
I would push it back. I was hoping you were including everything except for closed session.
Oh, I can do that.
If you're comfortable with that, I would.
I'm comfortable with that. I just wanted to make sure because it was a shared item you and I had. We didn't talk about it.
I'm good.
Okay, so colleagues, we're going to do another motion. We're going to also kick over to next month, item M2B, the public policy hearings and impacts of public calamities on public tax administration, County Board of Equalization Assessment Appeal Boards, remote hearings. And that just leaves N and O for us to deal with. So I'm going to make that motion to continue item M2B to the next month agenda. Is there a second?
I'll second that.
Thank you. Let's take public comment.
AT&T moderator, can you let us know if there is anyone on the line who would like to make a comment on this matter? AT&T operator, can you let us know if there is anyone on the line?
Currently, there's nobody on the line for public comments.
Thank you.
Great, thank you. Ms. Taylor, could you call the roll for this vote?
Yes. Chair Cohen,
Yes.
Vice Chair Schaefer,
Yes.
Member Gaines,
Aye.
Member Vasquez,
Aye.
Deputy Controller Stowers.
Aye.
Motion passes.
Thank you. Okay, so let's please call item N.
The next item is N, public comment on matters not on the agenda. Persons who wish to address the Board of Equalization regarding items not on the agenda. Please note that the board cannot take action on items not on the agenda. However, the board can schedule issues raised by the public for consideration at future meetings. AT&T moderator, please let us know if there is anyone on the line who would like to make a public comment regarding this matter.
Ladies and gentlemen, if you would like to make a comment, you can press 1 then 0 at this time. Currently, we have nobody queuing up for comment.
Thank you. Could you please call the next item, closed session?
Yes. Our next item is O, closed session. Discussion and action on personnel matters. The board members will now go into closed session to discuss personnel matters.
Thank you.
Members, just as a reminder, instructionally, please log out of the current Teams environment that you're in. There's a separate closed session Teams link on your calendar. Please use that link to join that meeting, and then we'll do the reverse coming back in. So thank you, members, for rejoining, and everyone else, if I could have you mute your mics and turn off your cameras. Thank you.
I'd like to come back into open session. Please note that it's 5:19 p.m. I'd like to make a motion not to disclose what was discussed in closed session. Is there a second?
So moved. Second.
Second made by Commissioner or Member Vasquez. I forget where I am now. Thank
You think
you.
in San Francisco still?
Exactly. Can we, Ms. Taylor, can we take a vote, please?
Yes, certainly we can.
Thank you.
Chair Cohen,
Aye.
Vice Chair Schaefer,
Yes.
Member Gaines,
Aye.
Member Vasquez,
Aye.
and I don't believe we would take a vote from Ms. Stowers.
That's right.
All right, the motion
Okay.
passes.
All right, thank you very much. Colleagues, I also, and to the members of the public, would just like to note that there's a possibility that we will be scheduling another closed session to take up the matters that we're dealing with in closed session in somewhere between 2 to 3 weeks' time. But we will confirm on a later date, and we will publicly notice that meeting accordingly. I see Mr. Gaines's hand.
Yes, I would like to ask the chair and fellow board members if we could reopen item L1B so I could vote. I was away from my desk and missed that vote on the translation issue.
Sure. All right. I'll make a motion to rescind the vote on item.
Ms.
Well,
Cohen?
actually, she's gonna bring back the item, no?
Reopen it?
Reopen.
Yes, I'm sorry. Let me
Correct.
pivot to Ms. Taylor. Go ahead, Ms. Taylor.
Chair Cohen, you may ask for a motion to reopen the vote, and if everyone agrees, then we can reopen a vote and take Mr. Gaines' vote.
Okay, I'll make a motion to reopen the vote.
Second.
All right. And let me call the roll. Chair Cohen,
Aye.
Vice Chair Schaefer,
Aye.
Member Gaines,
Aye.
Member Vasquez,
Aye.
Deputy Controller Stowers.
Aye.
The motion passes.
Thank you. At the appropriate time, could I do an adjourned memory?
Absolutely.
We first need to, excuse me, this is Ms. Taylor again. I do need to, let me go back to my notes here and
We need to
get
retake the
Mr.
vote.
Gaines's. Yeah, I don't know that we need to retake the vote. We can just ask Mr. Gaines what his vote was. This is on item L1B, board member and Board of Equalization website translation. And the motion was to move to have the ED explore and analyze and report back on this issue. So everyone voted, and Member Gaines, what is your vote?
Aye.
Thank you. The motion passed.
Thank you.
Thank you. All right, colleagues, let's begin to close out our meeting. Mr. Gaines, if you'd like to, close us out.
Thank you very much. Stockton Fire Captain Max Fortuna was shot in the early morning hours of January 31st while operating at a fire. He was transported to a nearby hospital where he died of his wounds. Captain Fortuna was 47 years old. He will be remembered as a man who loved his job and his community, very active in sports and very active with the youth within his community. He was a 21-year veteran of the Stockton Fire Department and a proud member of the Stockton Firefighters Local 356. Captain Fortuna leaves a wife and 2 adult children. And he rests in peace. Thank you.
Thank you. Colleagues, are there any other closing remarks?
Just if I may, Madam Chair.
Yeah.
You know, I think I'd like to continue at least adjourn in all of the lives we're still losing due to COVID. And we just lost another one here recently here in Santa Monica. Sad to say, though, this individual was not vaccinated. So it kind of brings me back to this whole issue that you know, while there's still people out there thinking that you don't need to get vaccinated, I'd like to encourage as many as those out there that are still not vaccinated that they really should reconsider, because I think those that are not are having a real tough time fighting this COVID. And I would just like to adjourn in the memory of all those lives we've lost since our last meeting.
Okay. I received that and join you in acknowledging the loss of life and the seriousness that COVID is still presenting, although masks mandates are coming down and things are relaxing. And colleagues, I also just want to note that tomorrow's meeting is officially canceled. And with that, we are in adjournment. Thank you for your service today. Have a good night.
All. Thank you, staff. I know it was a long one.
It was. Thank you, staff.
Thanks, everyone.
Thank you.